Order this City Commission meeting of the City of St. Pete Beach. Today is Monday, March 9th, 2026. It is 6 p.m. Let's stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
City Clerk, if you'll please do a roll call.
Vice Mayor Marriott.
Here.
Commissioner Robinson.
Here.
Commissioner Ruznicki.
Here.
Commissioner Maldonado.
Here.
And Mayor Petrilla.
Here.
We have a quorum.
Thank you. All right, are there any amendments to the agenda as proposed?
Like to add Country Thunder to the discussion items.
Okay. Any other changes to the amendment? Any other amendments to the agenda? Is there a motion to approve the agenda as amended?
I make a motion to approve the agenda as amended.
Second.
City Clerk, if you'll please do a roll call.
Vice Mayor Marriott.
Yes.
Commissioner Robinson.
Yes.
Commissioner Ruznicki.
Yes.
Commissioner Maldonado.
Yes.
And Mayor Petrilla.
Yes.
The motion carries.
Thank you. All right, next we have a few presentations. The first one is 2A, Communication and Small Wireless Facilities.
Yes, so in the presentation section, we want to talk about 5B a little bit. We have some people who are here to give presentations outside of public comment on the item and before all regular audience comment. And we have Scott McCullough, who's here from this Children's Health Network. And we have Matt Mucci, who's here from AT&T. And we wanted to give them time to make a presentation. And Francis, do we have them lined up on Zoom? They're on Zoom.
Yes, they're both here, and if, Scott, if you would like to go first?
Well-
You're muted, though, if you could unmute yourself.
I'll be happy to go first.
I believe we have
Thank you very much.
presentations. Your presentations were distributed as paper copies.
Thank you. That'll make things easier. I'm not very facile at talking and clicking at the same time. Thank you for letting me address you and to do so remotely. My name is Scott McCullough. I'm a telecommunications lawyer, been doing it far longer than I care to admit. The residents in your area, including Lauren and Kelly Lee, came to us and asked us to help them on this project. And, we've enjoyed working with your city staff and having the opportunity to present our views before you. Things have evolved a lot over time. This has been before you a couple of times. Where we are now is we pretty much have agreement with your staff and with your city attorney on all but about 3 issues. There's really only 3 that remain. We did just see their language that came out in the agenda on the driveway and fire hydrant distance requirements. We can accept that language instead of what we had. And so that's no longer an issue. There are 3 issues that remain. One is the setback distance. Staff encourages 30 feet to the dwelling unit. We seek a mandatory 40 feet. The second is a legal issue, whether FS 337-401 completely prohibits the city from requiring any separation between wireless facilities. And then third, more generally, whether any restrictions should be mandatory or only encouraged. So that they're basically just city preferences and maybe to be negotiated. I'm not going to go through all of the technical discussion in the handout. I gave you some background information on what these things look like, what's usually on top of them, and what you typically see in St. Pete's. I think the general takeaway is these things are usually about 40 feet tall. They got heavy equipment on top of them, and then in the middle, they become top heavy and they can fall in a high wind. I understand you have some high winds there. We think that a 40-foot setback is essential and a 30-foot setback is really not effective at all, and indeed it's probably almost meaningless. And that is because it's a 30-foot setback on a 40-foot pole. If it's set close to the property line, that thing falls, it's going to hit a house with about 10 foot of pole, with a lot of heavy equipment on it. And if it falls, these things, if it's still energized, it can cause a fire. There's going to be heavy shards that are going all over the place. The whole goal here is to avoid having a dwelling unit be hit. And that's really only possible if you have a setback that is equal, at least, to the height of the pole or the other structure. I've done this in a lot of places, and when we do setbacks, we always have it at least 100% of the pole or structure. And many times we add in more, an additional 10 or 25%, to account for things like the debris zone, stuff that breaks and flies out when it falls. So, you know, we appreciate the staff's effort on this, but the bottom line is 30 feet just won't cut it. There's also some other benefits, and I go through them. I won't repeat a whole bunch of it. It adds some adverse aesthetic benefit. It's a little further away from the property line. People won't have it right on top of them. And in 337-401, the language in that statute does allow you to have regulations based on location context. We don't believe that a 40-foot setback is going to be a de facto moratorium. There may be some debate over that, but what we've seen in the area is there will still be enough places in the area where a 40-foot setback on the side lot, even taking into account the driveway and fire plug issues, for them to be able to reasonably place facilities where they need to be. There are other places in the statute where you are allowed to do similar things. You know, there's language in the statute that allows you to have special language in places like historic areas. And that is so even notwithstanding the moratorium provisions. So I do not think that a 40-foot setback is going to be a moratorium, and I don't think that it's going to be what we talk of in the federal side as being an effective prohibition. Let's turn to the more contentious issue. We are also seeking a 500-foot separation requirement. And that is 500 feet between these wireless facilities. We're not talking about regulating where the poles are. We're talking about regulating where the wireless facilities are that go on poles and other structures. Now, I grant that the statute could be read many different ways. But when you look at the whole thing, in trying to sort through the difficult grammar and take into consideration other parts of the statute, I think it is certainly a fair reading that a 500-foot separation requirement can be justified. There's some judicial canons. When you read the statute, the way that it reads, especially when it concludes or at other at-grade communications facilities, I won't get into what all the Latin means, but usually when you have a set of things, and then there's one like here where they're very specific at grade, you can, many courts do, when it's ambiguous, treat all of them alike. And so I think one reading is that the separation language in the statute is really talking about at-grade communications facilities, not stuff up on pole. There's also some other issues here. You're allowed to take location context into issue. That includes aesthetic measures. And, you know, this is an aesthetic measure. What we're trying to do is ensure that no specific location has a whole bunch of other of these things. They're ugly enough on their own. We don't want a bunch of them really close to each other. It really upsets the view, especially treasured views like you have there. There are some places where the statute even actually preserves existing separation requirements. It allows the equivalent of a separation requirement to prevent any of the situations in 7D 11AF. It preserves separation requirements in an agreement that was entered before July 1st, 2017. It allows historic preservation zoning regulations to stay in effect even if they have a separation requirement. It preserves homeowners association regulations where they exist, including those that might have a separation requirement. Finally, this is a form of concealment. Now, that's a federal term. But what it basically means is when you conceal something, you hide it away, shield it from vision, treat it so as to be unnoticed. Certainly on the federal side. And by the way, the statute mentions concealment. It gives you power for them. On the federal side, this 500 separation requirement would be a concealment measure. So I think it can be justified under that too. So, we did give you one example, the city of Winter Park, where they have what I believe is a separation requirement, at least for other support structures. It may not include utility poles, but it certainly does support structures. So there's some precedent for this. Now, one of the other debates is, are we going to have a polite ask, or are we going to have a waivable requirement? We have agreed to the staff's language where they have the negotiation. And I'm going to come back to that in a second with the few minutes I have left. But, in combination with the negotiation requirement, I think you have a very good place where, if they want to come in with something that's less than 500 feet, y'all will have an opportunity to negotiate. And it may be resolved. So the issue may never really come up. Now, let me conclude. I know y'all are reasonably worried about getting sued. When I used to advise state agencies, I was with the State Attorney General's office, we were always concerned about litigation risk. It is a valid concern. But when you assess litigation risk, you also have to balance against the benefit to be had. Any business is always going to assess risks and benefits. And if there's a big benefit, you're maybe willing to take a little bit more risk. Here, I don't think that you face a large risk of being sued merely upon passing this ordinance. Let me tell you why. Yes, that language is in the statute that does allow them to bring suit. But that would be what we call in the law a facial challenge. In Florida, every facial challenge, you have the burden of proving that the challenged ordinance provision always operates illegally. There is no circumstance under which it can operate legally. Here, I've already explained to you, there are several situations where it can. So a facial challenge to your ordinance probably would not lie. Now, when could it come up? It would come up only if they apply for a permit, it is less than 500 feet, staff and the applicant go through the negotiation period, they cannot agree, and then you ultimately deny the permit because of the 500-foot requirement. Only then, I think, would you face a potential lawsuit over this. So the litigation on this is going to be on a case-by-case basis. You're not likely to face an initial facial challenge to this statute. I see my time has elapsed. I'll be happy to answer any questions.
Thank you, sir. Commissioner Robinson?
Hi, thank you so much for your presentation and for all your work with the residents here. I had a question. Where are things on the federal level on this aspect? And is the state of Florida one of the few states that has preemption, or is it one of many?
There are things happening at the federal level that do threaten to challenge local jurisdictions' authority in this area. There's some bills in Congress. There is an ongoing rulemaking at the FCC, where the commission is basically going to completely take away any kind of discretion that you have. Now, we are challenging that, we and many, many others, including all of the organizations representing state and local governments. We're all very much opposed to what the FCC is going to do, and we've raised a lot of reasons for why they cannot take away all of your power in this fashion. Now, what do I think the FCC will do? I don't know. I've practiced farmer for 40 years. I don't know what they're going to do. But yes, there's an effort to make things worse. I think it is important for you to get your ordinance strong as it is right now, so that if the commission does do this, then when there is litigation, and there will be litigation in the courts of appeals, then the city standing strong and trying to assert their local power and authority would do well. Now, in Florida, Florida is not the only state that has the kind of restrictive statute like you do. There are several others. Indeed, it's in the 30s, maybe the low 40s. They're not all the same, but they have some similarities. I think, however, the majority of states still give local jurisdictions far more power than you have. I would encourage you to keep working with the legislature to try to have them see the light, so that you do have the traditional police powers that local jurisdictions have always had in the area of land use. And maybe we can convince them to make things a little bit better for it. We have, however, tried to work within the statute in everything we've done.
I do another question, which is the 40-foot versus the 100%, or let's say 110 percentage. Why are you not looking at the 100%, considering if the towers could be 30 feet, 50 feet, and kind of settling in the middle?
We started out trying to get a much larger setback. We tried to take that into account, and indeed we wanted originally to measure from the property line. But in the interest of negotiation and compromise, we gradually came staff's way, and it significantly so. So we, instead of going from the lot line, we did go ahead and accept measuring from the dwelling unit, from the building itself. And while, frankly, we would prefer more, we were willing to go down to 40. But that's about as far as we can reasonably go. Yes, our 40 feet, if the pole is 45 feet, there's going to be a house that gets struck. We're just trying to balance interests here.
Understood. Thank you very much.
Commissioner Marriott?
Sure, thank you. I just have a couple questions for you. Is there any Florida case law that backs up any of these positions? If we the separation or the setbacks, is there any existing case law in Florida that would support any of those positions that we can count on or rely on?
I'm not aware of any case law on the separation issue in particular, and certainly under the state statute as it exists. I did, of course, shepherdize it. None came up. There were some older cases under the statute as it originally existed. Frankly, there was a case on payphones where the courts held that the local jurisdiction there retained authority on placement of payphones and some of the signage on it, even though it was also a matter subject to Florida PSC regulation. But that case was really more about whether the commission, the Florida Public Service Commission, or the local jurisdiction had exclusive authority. And the court said both do. I'm not aware of any instance where kind of it's really close to our issue right now.
All right. And then you said, in talking about the 40-foot setback, you said that that you think it would not be an effective prohibition against towers. If that were challenged, whether it was on a whole ordinance basis or a case-by-case basis, would that be up to the city to prove that that it's not a prohibition, or would that be up to the challenger to prove that it is?
The effective prohibition language comes out of the federal statute, and specifically 47 USC 332C7 B, and I'm not going to get into all the rest of the subparagraphs. In that circumstance, it would be the wireless company that would be filing, probably in federal court, and it would have the burden of proving an effective prohibition. It would have the burden of showing that it cannot effectively provide personal wireless service without getting that pole, that wireless facility on that pole in that place, that there are no alternatives.
Okay, that's good
And by
to
the
know.
way, you don't get your fees under the federal statute.
Yeah, all right. And then on the 40-foot setback issue, for it being a safety issue, is there any data that has been collected over time, or showing that these things have fallen over and damaged property or set things on fire? Like, do we have some data to back us up on that claim that it's dangerous, by being able to show that this has happened X number of times and it's caused X amount of damage?
I'm certainly aware of lots of instances where utility poles themselves have fallen. I think you might have suffered a few of those during the last storm y'all had. Whether there have been documented cases where it fell and it was because only of a small wireless facility on top of it, no, this is a relatively new kind of technology. We've only been arguing about small cells since about 2016. And so we haven't had enough time for any trend to be really discernible in terms of data analysis. But I'm sure that you guys have seen falling utility poles when you get storms. It happens all the time. And it happens for other reasons too. An automobile could strike. And there is an incremental effect that would occur when this is something more than just a utility pole or a light pole. You've got heavy stuff up there with sharp things, and it is electrified. Electrical equipment that really does have more of an impact when it does fall. It's not just a pole falling. It's a pole with a lot of equipment on it that's still pushing through electricity.
Thank you.
Any other questions? Thank you very much, sir.
Thank you again for the opportunity to address you.
Of course. Thank you. Matt, are you ready?
I am, thank you.
All right.
Just let me say, I'm not sure if this will be categorized as a presentation, but there has been comments made at prior meetings that a lack of representation may indicate that either we're not impacted or we are in agreement with what the city is doing. So my presence here today is to state the opposite of that. We obviously are very concerned about what the commission is considering, and I would just say that over the past several months, as it's been stated multiple times, there's been a lot of conversation, a lot of back and forth. I think AT&T has done an exceptional job of working with the residents, working with city staff, working with this commission to negotiate some good language. And I think some good language was agreed upon in the ordinance that was passed at the last meeting. Now, when it comes to the second ordinance, tonight's ordinance, it's simple. And I've said it once, I'll say it 100 times. What is being suggested will be in direct violation of state statute about what we are allowed to do in right-of-ways. So anything that is done to conflict with that is going to be a problem, and therefore that's why I'm here today. Again, I thank you all for the conversations we've had. We've listened to the residents. We even moved one of our small cell facilities off a pole that was something we didn't need to do, but we did in good faith. We had every right to be there, but we have since taken steps to move that one down to Gulf Boulevard again, as mentioned in prior meetings. So, again, I'm not an attorney. I'm not going to sit here and talk to you about what it is. I think you all know what it is right and what isn't right according to current state law. So I will just leave it there. I thank you for the time tonight. Thank you for letting me participate via Zoom. I'm going to stay on this call because there might be an opportunity later to address some other questions. I know the residents may have some questions that they would like answered, and if I can answer them, I will. So again, AT&T's position is this: in Ordinance 2 tonight, we are in opposition. Thank you.
Thank you, Matt. Any questions for Matt? Okay. Thank you, gentlemen. Next, we're moving on to the second presentation on seawalls. Who wants it?
We have our building official, Luke Curtis, who is coming on his way, hopefully.
My apologies. Thank you for your patience. There's a delay in watching it. So we're going to be talking about seawalls, and staff is just looking for some direction from Commission for possible tweaks or changes to our seawall ordinance. And to start off, we just want to say that the seawalls are in place for a specific reason. These are put in place to protect against tidal flooding. There is the potential that there are rainwater events that can possibly back up on the other side of the seawall, but in these instances, we're looking at two separate things. So we have the seawall to protect against tidal flooding, and we have other measures that potentially protect against the rainwater. But with that being said, give a little bit of history in our seawall ordinance. So our ordinance is in section 98-101 is where the seawalls are defined and the regulations are set. And a little bit of history on that. So in 2021, there was a slight change to the ordinance where it established or clarified the elevation requirement of 5 feet NAVD. And that's the North American Vertical Datum. And that means 5 feet above sea level. And then in September of 2024, we have the revision that was included in, or put into the code to allow for a variance process or an administrative variance. And for these instances where there was justifiable cause to allow for a seawall to be put at a lower level, this variance was put in place to accommodate for that. And then looking at the number of seawall permits that were applied for post-storm, we're looking at a total of, in the year post-storm, as compared to the year pre-storm, there was roughly double the number of seawalls that were applied for. So twice the number of seawalls from blue sky compared to the gray sky. And this is to be expected. We had a storm surge that came over the island that added water, where we had seawalls that were in disrepair or in rough shape. It collapsed them entirely. In other cases, they were damaged, not as bad. But obviously, the result was that the seawalls, or the number of seawalls, had to be repaired and replaced. For the sake of the conversation and for the variances that are requested, we have two basic or general areas that we're looking at as far as the situations on a property. So on the one hand, we have a non-conforming home that was built pre-firm or a structure that was built at grade, maybe a single-story home that was built prior to our flood insurance rate maps were adopted. And then we have on the flip side of that, those homes that were built after the adoption of the flood insurance rate maps, that these homes are either built up on an elevated lot or the home themselves are elevated, and thus bringing the living area outside of the potential for flood damage. And these properties, these buildings are going to be built so that the lower level is either flood-proofed, or so that if a flood water comes into the property, that they are either, there's minimal or no damage and it just needs to be cleaned up. The code section that we have for the administrative variance process, there's 5 criteria that we have to look at. So if we look at these criteria, the number 1 is there are special conditions of the upland subject property, existing upland structures or buildings, or vested and permittable upland structures or buildings which the applicant has taken reasonable investment-backed steps to construct, for which the application of the subject standard will present a hardship. So the best example for this would be that pre-firm or non-conforming structure, that single-story home that is built at grade. The living level might be at 4 feet. If that seawall is up at 5 feet, then there's a potential hazard for that living area. So that would be a clear-cut decision to approve that variance. The second one is hardship is not predominantly financial in nature. This is a standard practice for when we're talking about variances, whether administrative variances or other scenarios like that. I don't believe there's been any that have asked for a variance for the value or related to the value, but that is a standard verbiage that is in our code. The third section is application of the subject standard will imperil the subject or neighboring property. So in these scenarios where there's the potential that by elevating this, does it pose a hazard to the existing structure or the neighboring properties? And this, again, can be challenging to identify, but in certain aspects, when we're looking at development of any property, even the Florida Building Code says you can't do any development that's going to negatively impact the adjacent properties. So we need to see something in place there that's going to mitigate possible flooding. So if it's from rainwater, then you might see something in the example of swales or retention or detention or even infiltration trenches, something to accommodate for that. Point number 4, the hardship does not result from the upland property owner's unwillingness to modify the site to accommodate retention or detention of a 25-year, 24-hour storm, or such modification would itself rise to the level of a hardship that deprives the applicant reasonable use of the land, structure, or building. So going back to speaking of measures that can be taken on a property to help mitigate these flooding events, this is, when we're talking about the 25-year, 24-hour storm, it's looking at a certain amount of rainfall and being able to accommodate that on a property. And that can take numerous different forms. Again, so infiltration trenches or retention or detention areas on the property or swales. There's numerous different methods to do this. So this section here is looking at the property. Do they have the ability to do one of these measures to accommodate this type of flooding? And so looking at the example of, say, a conforming home, it's elevated. We have the area on the sides to accommodate that 25-year, 24-hour storm. But what is it reasonable to do, or does it impact that property? So that's one of the factors that we take into consideration. And then lastly, we have the variance requested is the minimum necessary to reasonably mitigate the peril that application of the subject standard would otherwise cause. So when it talks about the minimum standard, when we get these appeals in for, or not appeals, for the request for administrative variance, they're recommending a certain elevation of that seawall height. And what they've got to quantify that and say, okay, this is the minimum height that, or the maximum height that we can go without further causing peril to the property. So what do we need to take into consideration for changes? So there's a few different areas that we can look at. And the first is, do we want to add language to the code to require caps on seawalls to be designed for future upgrades to the required height? So in those instances where we have approved an administrative variance to lower that seawall, is that seawall designed so that at a future date that could just be added to and brought to that required height? And we can require that in the design. Also, potentially looking at the hardship variance would be granted if the cost to accommodate the stormwater exceeds 20% of the value of the structure. So this is another possible area that we could look at, is in that scenario where we're looking for retention, detention, or infiltration to compensate for that rainwater, are we overtaxing that individual? How much is that cost going to be, and is that going to be exorbitant? And we put the number of 20% in there just as a guide, but that could be any number. And if it exceeds that number, then that's justification to approve a lower elevation. And then we can also look at the specific criteria that we have. Do we want to modify that to make it easier for these administrative variances to be approved? We can lighten that requirement some in some of those areas, and to make it easier for those appeals when they come up. Or, we can take into consideration too, do we want to alleviate that requirement for the height elevation? There is some safety in having an elevation of the seawalls. Do we want to push that? Do we want to compensate for the rainwater potential flooding? And then lastly, we want to look at new construction. Is this a potential area where we want to set some other standards? So if somebody's building a brand new home is elevated, it's 100% conforming. They're going to have to make the lot conforming with landscaping, with stormwater issues. Do we also want to consider the application of requiring that seawall to be brought into conformance with the codes too? Lastly, I've got an image to try to help portray the elements that we're talking about. So on the one side, we have the proposed 5-foot NAVD, North American Vertical Datum, of the seawall. And then on the right, we have the 3-foot. In both instances, we have the potential of that rainwater backing up. Whether it's at 3 feet, 2 feet, or 5 feet, we have that potential. And again, the rainwater, we have to handle that separately than the seawall, because we're looking at two different sources of potential flooding. But with that lower elevation, we're also increasing the potential for tidal flooding, adding to that. So with a lower elevation of a seawall, we have the possibility of that being topped and adding to the potential flooding on a property or an area. So with that being said, going back to the 5 criteria, I'm open to any questions that you may have or any recommendations.
Commissioner Woznicki?
I'm going to have a lot of questions, only because I've been entrenched in this stuff. And I don't know, really, I mean, I wrote a lot of notes while you were speaking. Obviously, the ordinance was, back when it was made, and I'm just talking about the 5 NAV back in 2021, which I remember clear as day coming here as a resident, not very happy with it. and I'll go into why, I wasn't happy, because of what it meant for properties that lower lying, right? So, and then, I don't remember the variance at 2024, but the administrative, but prevention of tidal flooding, right? And then you mentioned other measures for rainwater. What are those other measures? What other measures are there?
So I mentioned some of those. So they can be handled in a lot of different ways. So we can have, so if we have a structure, and on the sides of that structure, we can have swales. What a swale is it's just basically a cutout, a low area in that lot that can direct stormwater to the street or off the property so that it can be directed into the storm drains. There's other methods too that can be utilized, such as retention or detention. And sometimes, in some areas, some municipalities, they actually, what they do is they have these retention or infiltration areas. And what they do is they dig the dirt down, pardon me, they dig the dirt down and they fill it up with stone to allow space for that rainwater to go. So it creates a void, if you will, to allow that storm water to give it time to percolate down into the ground. And by using a method like that, it gets it off the top of the ground into that infiltration area, and it is less impacting on the property itself, and it's less impacting on the storm drains.
Is that required right now for a property owner to have to do those types of measures when they build a seawall?
There aren't any requirements in there. Now, our code does mention swales to compensate for certain things, but not in the seawall ordinance. There are triggers like building a new home where they have to take into consideration these measures and accommodate the 25-year, 24-hour storm. But I don't, outside of the mention of swales, I don't think it mandates any specific process or procedure to do that.
Okay, so in that case, seawalls are just for tidal flow, they're not for rainwater. If we're not requiring it, then we're really not protecting a home or a neighboring home on rainwater currently.
Correct, yeah, the seawall isn't providing any protection from rainwater. It's providing protection from the tidal flooding potential.
Okay. Next, you mentioned pre-firm home, non-conforming, and post-firm. I kind of am worried about using pre-firm and post-firm, and this is a question, I guess, to you as to how we'll deal with this. There are some, there was a year, and maybe you remember the year when pre-firm and post-firm was made, 1980.
74.
Someone knows. 86?
74 was the first
74?
map when it was adopted.
There are homes that were built during pre-firm, but are considered post-firm, but were designed as pre-firm because it was in that iffy year, okay? My home is one of those, okay? So I'm very familiar with it. So using those words without taking those homes into consideration is a false, to say that my home is prepared to take in flooding when it wasn't designed to do that. And there's a lot of homes that were built in that time currently in our city. So that would be one concern with the number one that you have here for administrative variance, is being cautious of using pre-firm or post-firm as a determination of a home being able to take in rainwater or stormwater flooding. So that's one. Number two, I didn't really have nothing because financial, I know it's not a requirement. But three, the imperiling of the neighboring property to not negatively, impact an adjacent property. If we don't have a standard to prevent rainwater flooding when building a seawall, then that's a problem because people don't know that they need to build this. And then from what I've heard from many people who are trying to contain their rainwater, and even if it's new construction and put vaults or swales or whatever it may be, there is no standard. Our ordinances don't allow it in many cases. So that's another problem. So that's not a question, but that's just a comment because it's a problem with that number three. Being able to accommodate rainwater on a property, on the number 4, that 25-year, 24-hour storm, that's pretty heavy duty for some properties, right? Like how, when you already have a home that's there, where would you put all this water? You know, especially in an area that's already low-lying. You don't have much to go down when your groundwater is pretty close to you already. So that's a big concern on that number 4. Even the way it's written there, it's almost like it's not doable for many areas in our city. So that's a big concern for me. And then recommending a max height without causing peril for that number 5. Or was it maximum or minimum? I think you used the word max. I don't know
Yeah,
why.
the minimum elevation of that, the proposed minimum elevation of that seawall that will,
But were you mentioning during the presentation a max height? I don't know why I wrote that down. That you would be recommending a maximum height without causing peril?
yeah, so what that point is saying is, so when we receive a request for an administrative variance, we get a letter from a professional engineer, and they're stating in there, this is the maximum height that we want to see the seawall at before it starts to become a potential peril to the property. So that's what that's in reference to, is that maximum
Max
height is
from
reasonable.
the contractor or the engineer, basically.
Correct. It's
Well,
on-
more so the engineer than.
Yeah, the onus is on the engineer, because they're the ones that are versed in coastal construction and where that peril lies.
Now, what type of guidance does an engineer get in that? Because, and the reason I asked you this is because I'm trying to get a seawall myself, and when I've asked various contractors, they all just look at the ordinance. If the ordinance says 5 nav, then they're bidding a price to a 5 nav because that's what our ordinance is. And I asked many contractors already, because I've been trying to get bids, if a city doesn't have a 5 nav ordinance or any at all, or really no guidance, what do you typically do? And so they told me, you know what we do is we go to your home, we look at what your floor level is in the back of your house, if your seawall is behind your house. We get a laser and we point out to make sure that we can't go over that point, or whatever that point is, so that you don't have water coming back on a rainwater, what we're trying to protect here. And that's how they determine it. So I don't know, how do we guide people to an engineer to say, do I hire an engineer to say, hey, just make it so that I don't have to go to a 5 nav or a 6 nav or whatever our nav is, because I'm going to get flooding, when it's an obvious, So I don't, the wording is so hard when you're asking for a variance, when we already know the areas in our city that are low-lying, okay? And it's not just the Don. I know everyone says the Don. Well, there's several areas in our city. I know places in Bella Vista that are having issues right now trying to get their seawalls up when a neighbor is getting a new construction, but the abutting property owner is much lower, and they know all that water is going to run to their house. I know you know the calls because I send them to you, right? So I know there's this issue in our city. So again, the wording, I know we're trying to give recommendation, but I know there's a lot of issues with this ordinance. And then, of course, which I know we're going to talk later, about right-of-ways, when they abut a right-of-way. How can we contain water? That's a city right-of-way, right? So how do we even address that when there's already a significant hardship, because we know, A, the road is lower than the house, so there's no way for the water to move. It's going to sit on the road, and then it's going to come back to our home, right? So that's a huge problem for a lot of people, not just Adon, Bella Vista, parts in Lido, all the same, that their road is lower than their home, and the water just sits in there, right? So it comes back. So that's a big one. And also with the elevations of the, I'll give an example, Vina, right? Vina Del Mar is much higher. It's filled. You look at those homes, and I could stare at them, from my house. The water rolls down to a 5 nav seawall, right? And the other side of the water, it'll never do that. So unless every home in a neighborhood are to raise and fill, we would never look like Vina. So I don't know, it's really hard to get one variance that's going to accommodate the variety of everything going on in our city. So I guess that's a question to you. How do we get there? Knowing, you're trying to manage our floodplain, but our floodplain is not the same throughout St. Pete Beach.
Yeah, and to comment on that, one size does not fit all. So depending on where the property is and what the elements or conditions of that property are, they might be different from one to the other. So yeah, it makes for a difficult process. But, and that's part also why we're here, to try to get some feedback on what direction Commission wants us to move in as far as making alterations or changes to our code. In some instances, like Vina Del Mar, we might not want to approve any variances because they're elevated, and that neighborhood, they're going to have the seawalls at the required height. Not to pick on that neighborhood, but like you said, they're elevated to a much higher level.
There's a reverse to that too. They're elevated, but I know there's people there who want to go higher than 5 nav and could,
Yeah.
So why not allow someone to even go higher if it was going to improve, it's not going to impede into their home, it's not going to flood a neighbor, why not allow them to go to 6 or 7 if they have the capability of doing so?
And that's something we can take into consideration too. Do we want to limit how high a seawall goes? We can add that in there. I know in another municipality that I've dealt with, they have a limitation on, just throwing this out there for what they put in there. They didn't want to see where one property was so much higher than another property, so they said you can't go any more than 16 inches higher than the adjacent property. And that was to help mitigate any possible surges being deflected off that seawall and impacting, potentially negatively impacting those adjacent properties. So that municipality put that verbiage in there. And it would take, ultimately we want to get these seawalls to a higher level, but they're like, case in point, where you live in your neighborhood, grade itself is so low that how best to handle that. And like I said, we have the seawalls to protect against the tidal, then we have the other side of it to protect against the rainwater. Because even if we have a lower elevation for seawall, we still have that rainwater we've got to deal with.
Correct. And the last part, and the considerations, just so that the commission can also hear this part, because you're saying to be able to, in the variance, to allow them to go up higher, right? To make the caps engineered so they can go up higher if needed. Why just caps? Because I've spoken with contractors who tell me that they don't have to just go higher in a cap. They can do other things behind a seawall to increase in height. So there's other alternatives to not just adding on to your cap. Even for someone who's currently at a lower cap, has a good seawall, something can be done adjacent to the seawall to give it that height. So that's just, consideration that hopefully maybe you would consider instead of just caps.
Yeah, and that can be something we have seen in other areas. They weren't looking for a lower elevation for the seawall, but what they did is they had the seawall elevation at the 5 feet, but then they also had a step up backing off the property. It was a commercial property, but there was a step up that brought that potential protection from tidal flooding even higher. So that is a potential that we could incorporate into provisions in our code.
For the variance, okay, so that's a good thing. And then you mentioned hardship exceeds 20% of the value. What are we considering the value? What's the value? What's that number from where?
So typically when we're looking at a value, we're looking at the building. But it could be attached to anything, and it would be at Commission's direction. Do we want to look at the value of the building? If we look at the value of the seawall, compared to the value of potential infiltration or detention, retention, then that number's going to be exponentially less and might not be a good gauge. But it's all up to you and how you want to direct us. We can attach that percentage to the structure. We could attach it to the seawall.
So we just determined. Okay, thank you.
Commissioner Robinson?
When you said doubled amount of permits, are you talking permits in general for seawalls, or are you talking for variances?
No, just permits in general for seawalls. So
What's that number?
The number of permits, and actually I don't have it right here. So I can tell you the total number of permits. Well, pre-storm, that previous year was roughly 30-something. I thought I put it in my notes, but I don't see it here. And then that year post-storm was in the 70s as far as how many applications came in. But since the storm, we've seen a total of 83 seawall permits that have come in. That's taken from October 1 of 2024.
And how many of those are asking for variances?
I don't have that information. I didn't think to pull that. My apologies.
Okay. And where did we get the 25-year, 24-hour storm?
So that's a standard practice in the industry. They look at that. There's a standard, and I can't give you the details because I typically don't. That's something that an engineer is making determinations on. But it's something that's factored in the building code. It's called out, and it's a standard for how much rainfall within a 24-hour period that could potentially fall. And then that property is supposed to be able to handle that amount of rain.
So is the standard in the building code industry?
In design and engineering standards. I can get more details on that for you if you like.
Is there a FEMA limit on heights on the seawall caps?
No.
And this doesn't address any sort of the backfill issues at all, correct?
Correct. Yes.
Backfill's a huge one. I mean, we're looking at people that, you're looking at the folks that are post-firm, and they're going to get, flooding into their garages.
Yeah, and as far as, now you're referring to like requiring fill for a new home, or?
Just in general, backfill for both a new home and also backfill for what we can do behind a seawall itself, too.
So there's no requirement for the fill, but the code does call to a limitation on how much fill. So for example, in certain areas, you're not allowed to do fill. So in a VE flood zone or a coastal A zone, it says no structural fill. For the instance of an AE flood zone, if you're utilizing a stem wall foundation, then there is some fill allowed in that stem wall. Outside of that, the code says fill can be used for landscaping and for grading the property, but it doesn't have any requirements for it.
And then have we talked about, some of the other, I'm thinking criteria, I think Al-Kazi had mentioned sump pumps, which I thought were a great idea on some of these areas too. Whether that's an idea that is something that could be part of any sort of code or requirement as well, whether that's a reality.
So for requiring sump pumps on a private property,
Private property, or for with the seawall, with the flooding for the rainwater prevention.
So and that is a possibility. Adding some verbiage into the code to require it. I know there is at least one property, a commercial property, that does utilize a pump to get rainwater off their property, because over time from filling or doing work on the front of the property, and then the rear of the property is raised, they've come to a point where everything drains towards the building, and so they have a pump on either side of the building that gets that rainwater out of there. So that is a possibility, and that would kick back to the point number 4. If somebody wanted to manage that rainwater that way, then that would be a possibility. I'm sorry, I didn't mean to point to that.
That's okay.
But yeah, that is one means of accommodating that potential rain flooding.
Because I believe this drain here is two-way. correct? It can go inflow and outflow for the drain, on the seawall drain? Am I-
Yeah, if they're, well, sometimes they design seawalls with what they call a well point. And what that can do is if there's upland water that's accumulating, it will allow the water to exit out of the seawall or from behind the seawall. But if there's an equal pressure on the opposite side, then it's just going to stay stagnant. So it doesn't do, it has the potential to alleviate some pressure, but it would be limited.
I just think there's a lot here with this, that there's a lot more probably discussion that needs to be had on it. I don't have waterfront properties, so it's a little bit beyond me, but a lot of people do, so I would look towards, some input from them as well on this. Thank you.
Commissioner Marriott?
Yeah, thanks, Luke. So you said you didn't know how many or what % of the people who've applied for seawalls are asking for variances. I mean, just as a rough estimate of your general feelings about it, is it a handful or most of them?
No, it's relatively few.
Okay.
They typically come to me,
Yeah.
and
I mean, I'm not looking for a number. It just
maybe
just a rough
8 to 10, just
Okay.
off the top of my head.
Yeah.
Since the storms, that, give or take a few maybe, but relatively speaking, out of the 83 seawall permits, it's a relatively low number.
Yeah. And are there, I mean, I'm assuming you're bringing this to us because there's some where you're like, man, I feel like there ought to be a way to give this person a variance, but according to these criteria that I have, I can't.
So, yeah, it was kind of the opposite. I was hesitant about giving a variance for one, but there was enough argument to be made that made me reverse that.
Okay.
And what it came down to is the verbiage in these 5 criteria. In this instance, it was an elevated home, post-firm, and I meant to get back to Commissioner Reznicki's point, post-firm, pre-firm, we do have to be careful with that, because we can have a post-firm home that really isn't compliant with our flood regulations. So we do have to be cautious when we're referring to those. I use them in very general terms for the sake of the conversation, so just to clarify that. And I apologize, I lost my thought. What was the question again?
Oh, just if the problem was that you felt like you
Yes.
should give variances, but you can't according to the criteria, or you feel like the criteria is too lenient.
So in this one example, the home was elevated and no living area on the ground floor. But the issue was raised that while the seawall is going to be higher, it's going to be, I can't remember the specifics, but basically it's going to potentially impact the pool deck, the pool, and entry into the house. And then there's contention about dealing with the rainwater, because it was all about the rainwater potentially backing up on the property. Is the specifics of the project, I can't recall exactly, but that was the basic gist of it. And then it made it difficult too, because as far as compensating on the property for the handling of the rainwater, well, how do we get it off the property? Is there a way to do that? And basically it came down to that it was a very difficult decision to make, simply because of all the criteria. So we look at, does it imperil the structure? And then we're going down to number 4 and saying, well, what about handling this rainwater? What are we going to do? Swales, infiltration. And then it came up about doing that work is going to be, it's going to be an excessive amount of work. So it wasn't an easy decision to make, but I did recant it and I approved the administrative variance in that scenario. So, and that was, I think, the latest one that made us come before you, looking for direction. How can we at the very least, clarify this to make these decisions easier, or, however we want to go. Do we want to relax them a little bit? Do we want to stand firm?
Yeah, that's a tricky one. I agree with Commissioner Robinson that, I feel like this is one where some public input from the people who are most directly affected wouldn't be a bad idea. And, on the one hand, I can go, well, if a bunch of people raise their seawalls to 5 feet and we have a storm like an Eta or an Idalia, and it, nothing would have flooded except for the handful of people who have lower seawalls, and then the water overtops the seawall and floods a bunch of people's houses anyway. And then the rainwater issue is a separate issue. And so it's like, what are we most trying to protect against, and what is the point of what we're doing, right? Are we trying to protect individual houses the most? Are we trying to protect the island as a whole the most? How what is the best way to do that? And like Commissioner Robinson, I also don't live on the water, so I'm not as intimately familiar with it. But off the top of my head, my initial reaction would be that there's a lot of variables here, and if it makes sense, anytime it makes sense to you to think that that's the most reasonable thing to do to grant a variance, it seems like we want to be giving you enough leeway to do that. But I do like the idea of some kind of requirement, whether it's a cap on a seawall or something else, but some kind of requirement where if somebody's putting in a new seawall that's not to the current height, that there is some definite path for the next owner or down the road for it to get raised up if the house gets torn down and a new one gets built. So for what it's worth, that's my uneducated thoughts.
Luke, you're looking for direction tonight, right?
Yes.
Okay. What direction are you looking for?
So a couple parts. So we see the administrative criteria as far as making these decisions. If commission can give us some direction, and by some of the comments, I think we've gotten some direction there. But if there's any specific direction outside of that as far as how we want to modify the codes, if we want to modify them at all, especially the administrative criteria, do we want to tackle that? Do we want to try to ease those a little bit? Do we want to stand fast?
Luke?
City Manager, did you have a recommendation? Is that what you're asking us? Because what we have here, it just says for consideration.
Yes, I know. These are not considerations. These are your current codes. If you could go to the next slide. This is what we're living with, what you were just looking at.
Mm-hmm.
So we want to hear, no, go back. We want to hear generally from you direction on, as the building official mentioned and Commissioner Marriott spoke about it, is do you want us to include language that requires future upgrades to get to the required height if they cannot because they need a variance? So that's number one. On the requirement to put some sort of storm water mitigation on their private property, we wanted some value. Do you want to give a value attached to it so that we have some more additional guidance on expense? One of the considerations we were looking at, I think the example he gave where the stormwater mitigation was more than the cost of the seawall. Well, now it becomes cost prohibitive, and so the resident now won't have a seawall and won't have stormwater drainage. So, kind of just giving us general guidance, what is the priority? Administrative relief, there's no appeal of the building official's decision in the current code. Do you want to provide that to residents or not? Or is he or she the final say on the administrative relief variance decision? And then lastly, new construction. There's been some discussion of requiring 5 NAVD seawall and stormwater on new builds. So that's completely demoed and rebuilding on the water. We currently require stormwater, but there's no requirement in the code for seawall. I say that with the caveat that everyone that's rebuilding has been doing the right thing, but do you want it in the code for future in the event that someone decided they did not want to build a seawall? So these are, and then anything else you've heard in the community, give us feedback, then we can come back with some language, and I'm hearing maybe some normalizing with the community. We could do a community workshop with that new language before we brought it back as an ordinance reading.
Commissioner Maldonado?
Yeah, just, thank you. And you did answer two of my questions in that process. I would just say that we need to add an appeal process to this, that in the event that there's no agreement and that we may have put somebody into a very difficult situation, as our city manager said, that we don't just leave it like that, that it does have an appeal process. Thank you.
I'm also in favor of the new construction, making sure that they're being brought up to code. And I think because of the number of, or the lack of number of impacted individuals, I'm not sure that we need a community-wide workshop for 8 to 10 homes. I think what we have here is a solid proposal. And if the commissioners are agreeable to what's been proposed, we will always have additional public comments at the 2 ordinance readings.
Can I ask, for new construction, I'm all for, people doing their seawall for new construction, but how do you incorporate the impact on an adjacent home? Because if you just say at new construction you have to do a 5 nav or whatever it is, but they can't mitigate the stormwater, in an area that is low,
So
then how do we deal with all of that,
for a new home, it's required to be in the design. So, and that can take different forms, like what I was mentioning. But in essence, whatever rainfall hits that property is responsible to retain it. And part of this, too, falls under our impervious surface ratio. So we can only have so much impervious area on a property, because if we have bare ground, grass or stone or whatever, that is allowing that rainwater to percolate down into the ground. That's ideally what we want. But above and beyond that, if that volume that is potentially hitting that property exceeds that amount that can percolate down into the ground, then they have to provide some means to handle that water, whether it's swales, which we see a lot of the times, to bring that water, that rainwater, to the street and ultimately into the storm drains. That's one method, but it is required for all new builds to compensate for that 25-year, 24-hour storm.
Then I would only add for the new construction, for the unique situations, which are very few, but there are a lot, where their seawall is not just their property, right? The Don is an example. There are 2 legal descriptions when someone owns a seawall over there, separate from their home. We've got a 50-foot right-of-way. There is no way that someone doing new construction is going to be able to mitigate what's happening across the street when there's a street that's lower than their property. So that has to be added there somewhere, because there's no way. The calculations wouldn't even make sense if you're looking at it from just where the home sits and the seawall is across the street.
Right, and that's actually a perfect scenario for the variables that fall into play, because with a new home, they're required to handle that 25-year, 24-hour storm on that property. But if we're talking about a separate property that's now across the street, what do we do there? How do we handle
The city
that?
recognized that there are 2 legal descriptions in that neighborhood. So if you're doing a new construction in the Don Cesar subdivision, it doesn't apply. Is that what you're saying?
So
A new construction, someone's building a new home in the Don Cesar, seawall is separate because it's another legal description.
Correct.
Okay. Commissioners, do we have consensus on these items?
Yeah, I think all of the recommended considerations here are reasonable.
Yep, I'm good with that.
I don't know if public comment will come after. I know there's people from seawall presentation here.
I mean, we usually don't take public comments on presentations.
sorry.
Yeah.
Is the appeal, when we're talking about the appeal process, are we talking that going to the commission, or are we talking that going to the city manager?
It would not come to me.
It would come to the commission.
We want to
Adjustment?
play around with that because you want someone who actually knows engineering and building, so I just want to talk with staff, like, what's the best route? Would you have an outside advisor if it did come to you? Those are things I've seen done in the past where we hire another engineer to come advise you while you're contemplating it. So we'll bring all that back and when we bring some proposed language.
Okay. Does that give you enough to work with?
It does, thank you very much.
Thank you. Next presentation is on the parking rate study.
Good evening, Commissioners. Adam Poyer, Assistant City Manager. Just a second while the PowerPoint changes. Just to give you a little bit of a background on this, as you know, I was in front of you last meeting for a component of the parking, but like I mentioned, this is kind of a very comprehensive overview of our parking system, which resulted in a parking action plan from Dixon Resources back in 2025. It kind of resulted in several recommendations stemming anywhere from technology to signage, enforcement, ordinance changes, and then revenue. So based on your direction, revenue was seemed like the priority. So although we've been doing other things as well, we wanted to bring some revenue options back to you as quick as we can. Another component of this was we created an enterprise fund this last budget year to manage the parking system more effectively, both revenues and expenditures. So that is already in place and moving forward. So tonight, like I said, we're going to focus on the revenue portion of parking. So for lack of a better term, what I've prepared, what our staff's prepared for you tonight is kind of an a la carte options for revenue enhancement. So I'm going to kind of go through each one of them separately and kind of tell you what the potential increase in revenue could be. But a couple caveats to that. None of them build on each other. So when you see these numbers, it's not assuming that you're going to accept all of them, okay? So it is a la carte right now. I will show you what it looks like if you do accept all of them as well. But the actual numbers of increased revenue are just based on the individual components of it. So it's also based on historical data. So we look back from 2025. So we're looking at a 12-month period. Obviously, we went through a significant event at the end of 2024, which could have altered demand to some degree. So, those numbers are, again, estimates based on that 2025 demand. So, all right, so our first option that we have in front of you tonight is updating the citywide hourly rate. So the proposal in front of you is to raise it by 50 cents per hour. Again, based on the current historic data, that would raise you about $600,000 per year in extra parking revenue. And then your new rates would result in $5 per hour during the weekdays and then $6 per hour on weekends. So we right now we have two separate rates, obviously. Weekends are Saturday and Sunday, so that would be $5 and $6. And please feel free to stop me if you have any questions on any. I'll go through all of them, and then I'll give you a chance to kind of look at them all together. The next one that we have before you is, so basically, all of our parking is done through credit cards. There's not a cash option anymore. So what's kind of being seen in other parts of industry is passing the credit card rate off to the customer. Right now, we handle the credit card rate as the city. So if we were to pass that credit card fee over to the users, that would bring in about $170,000 annually. When we developed all these kind of a la carte options for you, some of it came through the parking study by Dixon. Other is our staff. Huge thank you to Kathleen, who did a lion's share of this work, looking at other communities and kind of seeing some of the techniques that are used in other cities, and also ensuring that we kind of stay consistent with other communities. So one of our local communities is doing something called a sunset pricing. So we do see demand increase a little bit in that kind of nighttime range, 4 to 8 o'clock. In most areas of our city, 8 o'clock is the last hour of enforcement. So we presented a sunset pricing increase, which would raise the rate by $1 from 4 o'clock in the afternoon till 8 o'clock at night. And basically what that would do for you is bring your weekday price to $5.50 and then your weekend price to $6.50 after 4 o'clock. Again, none of them build on each other, so if you were to choose the 50-cent option, then obviously that would raise the rate to $6 during the weekday and then $7 on weekends. And just to give you an idea of the demand during that time, it's about 20% of metered sales. So when we looked at the metered sales, I should say, we don't have the numbers of how many cars that results in. What we do have is how many transactions it is. So we're looking at demand periods by transaction. So conceivably, it could be the same car that paid for an hour, it expired, they came back and paid for another hour, things like that. So it doesn't necessarily mean how many cars, just means how many transactions occurred during that period. And like I said, that would bring you, and maybe I didn't say it, but it would bring you about $257,000 if you were to choose the sunset pricing option.
Do you know the transactions, like how many there are?
I definitely have that. I don't know if I have it readily available. I'll look as soon as this presentation's over, but yes, we would be able to tell you that for sure. I'll tell you just in general, over 2025, it was over 621,000 transactions, So one of the other options is to raise our seasonal rate. So again, when we look at demand periods, 34% of the demand comes between the months of February and April. So we're going to consider that our in-season times. Obviously, we're right in the middle of that now. So we could, if we increase the parking by $1 during the season at all of our city facilities and our county lot, which I'll talk about here in just one second, that would bring in about $425,000 in additional revenue. So I mentioned the county park. So the county park across from Dolphin Village is a shared parking agreement that we have with Pinellas County. They own the property. We handle the enforcement. We handle the maintenance at the restroom facility. We're also able to sell concessions in the back with the umbrellas and chairs and things like that, so we manage that as well. There's some other components to it. Right now, the pricing is different there than the rest of the city, so it's actually cheaper to park at the county park than the other facilities. Through some research, we noticed that the county rate isn't consistent all the way up the beach at all their lots. Ourselves and our legal team reviewed the contract. It does not appear that we're contracted to keep any specific rate. It looks like the rate is up to us. We do the enforcement, we do the collecting, and then we pay the revenues to the county on a split agreement. So we believe we can standardize that rate with the rest of the city so that they're all the same, and that would bring in about $90,000 extra per year. And I noticed Pastor Girl spelled wrong on there, so I apologize for that. I'm missing an E. So one of the options we were asked to explore at some point was, what about those slower demand periods? Could we lower the rate a little bit in a slower demand period to maybe boost some traffic? To be honest, we don't really have too many slow demand periods when you look at a 24-hour period or really just the main enforcement time for all of our city parking. We calculated 8 to noon just to show you, but I can tell you starting at about 10 o'clock you start seeing a pretty significant spike in demand, but we did want to provide this to you. Another thing I will tell you is the technology continues to be enhanced in the parking field. A new company just took over 2 of the platforms that we currently use, and I know Kathleen's already seeing some great technology increases and advancements in that, which I think at some point we'll probably even be able to be more flexible, where we're kind of changing pricing based on real-time demand. We're certainly not there yet, so we wanted to at least give you an option of something that we could manage today based on the technology. So this proposal would reduce the parking by $1 across the city from 8 till noon, and if we were to do that again based on current demand, it would reduce your overall revenues by about $405,000. And again, when I say reduce or increase, certainly reducing the rate may drive demand, raising the rate may decrease demand. Those are all unknowns. But again, now that we have that enterprise fund and we're managing this a lot more actively, we'll be able to make those adjustments and bring those things back to you if we start seeing a change somewhere. So just a couple other possibilities. I mentioned that the weekends currently are Saturday and Sunday. Again, when you start looking at those transaction spikes, they spike on Friday. So we're over 100,000 transactions on Saturday and Sunday. Friday is in that like 80,000 range, and then the rest of the week is like 30s to 50,000 transactions. So certainly your spikes are on Friday, Saturday, and Sunday. So if we started considering Friday part of the weekend, that would add $120,000. Another thing that we do that a lot of other communities do, certainly you'll see some businesses along Gulf Boulevard do this on holiday weekends. So we're talking Memorial Day, Labor Day, and 4th of July. It would charge a flat fee. So the commission voted to do that probably about 4 or 5 years ago. So we started charging a $25 one-time fee for parking on the holiday weekend. So we just put a number in there. It could be anything. We did the figures on 40. So if we went from $25 per transaction to $40 per transaction, that would bring in about $480,000 extra per year. And again, we're talking Memorial, Labor Day, and 4th of July.
Quick question.
Yes.
What's the hours for that? Is that just all day?
It's all day, yes. It's to do those holiday weekends, yes.
Okay, thank you.
So, again, just to give you just a one slide of all the possibilities. So this would be implementing all of the possibilities and just kind of a quick description of each one that I explained. So basically, if we added all the increased revenues and we also did the $1 reduction till noon, which again reduces it by $405,000, you'd be looking at about $1.7 million in increased revenue annually. About a month ago, we did a very similar presentation to the Finance Budget Review Committee, kind of going over all this and data and looking for a little bit of direction from them. I will tell you unanimously they supported everything but 2 of the proposals that we provided to them. The 2 they did not support were passing the credit card fees on to the end user, and then they also didn't support the reducing the rate from 8 to noon by $1. So the slide you have in front of you would be if you were to implement all the things from the Finance and Budget Review Committee, you'd be looking at about $1.9 million because, again, you don't have that reduction. You do have a reduction in the credit cards, but you don't have that large reduction in the hourly rate. So just a quick summary of the of what your new rates would be if you were to adopt all of these. Your citywide rates would go to $5 an hour during the weekdays, $6 an hour on the weekends. You'd have that sunset surge to $1, and you'd also have that surge during the end season, so you can kind of see what part of the season you'd be paying what. On the most expensive scale, you'd be looking at your sunset fees during your end period. Your seasonal period would be as high as $8 on weekends. Again, that's a limited time of year. Again, making Friday part of your weekends, you'd have that $6 basic rate throughout the year, and then the $40 on the holiday. So like I mentioned, in the actual parking study, they did provide some kind of benchmarking. We just put our 2 local ones on there just to give you an idea where you're at. Madeira Beach right now is $4 an hour. Treasure Island is $4.95 during the weekday. They surged to $5.95 on weekends. And then they're one of the communities that add that $1 extra for the sunset. We didn't add it to the slide, but I will tell you they also have a special events rate where they do that single rate throughout the day, and they do it for some of their bigger events, but it seems to fluctuate a little bit, so we didn't add it to the slide. All right, so final slide is just kind of giving you a what's next. I'm going to go back a couple just so I can hear your input on it, but basically tonight you're going to have your second reading of your ordinance, which allows us to adjust the rates via resolution. So just a little bit quicker for us to come to you and adjust these things. And again, it could work both ways, right? So parking rates isn't just a revenue generator. It's also trying to turn over those parking spaces, which can benefit businesses by getting more people out here. So there's a lot of components of why you'd want to use the rates to manage your parking system. But certainly, we're trying to put things in place so it's quicker for us to come to you and make adjustments when we see the need to do that. Again, we'll bring back, as long as we get some good direction from you tonight, we'll be able to draft a resolution to bring you in the following meeting, which would actually increase the rates, and then we'd start working with our technology vendors to make sure that we implement those as quick as possible. Our next step from a revenue perspective is now we're going to start looking at all the fines. We've really already started doing that, but we're going to look at all the parking fines, the tickets for not using meters, parking too close to fire hydrants. A lot of them are state regulated, but there are some that we have local control on, so we'll be bringing those back to you as part of a supplemental part of this project. And then apart from fees and revenues, we're working on a bunch of other things as far as our technology. The license plate readers will be going out to bid that we use on the vehicles for enforcement. We're looking at some creative ways to really maximize our enforcement efforts so that we can get our parking enforcement officers throughout the city more quickly and enforce more. Improve financial reporting, again, by creating that enterprise fund and now managing it through the city manager's office. We have a much better handle on the overall parking system, and I think we're going to continue to see improvements of that. We're evaluating the signage throughout the city, so we're looking for missing signs from the hurricane. We're looking for faded signs. We're looking for signs that just maybe are confusing or just don't make sense, where we need to clean up the language on it a little bit. Maybe there's something that, you know, more no backing signs, that there's just not enough of those. So we just provided a pretty long list to public services of things we've already found. So those will be being implemented over time, and we're continuing. I'll tell you, we get a lot of feedback from the residents as far as parking, so we're constantly looking at where we can make you know, enhancements to help the user experience for our residents and our visitors. And then finally, we're going to be looking at resident parking, like I mentioned, one of the most common things that we hear about. So we're going to be looking at ways to enhance that for our residents. That could include anything from, we're looking at adding adding golf cart spots to the north end, where we do have some, in the south end already, but we don't have them on Upham. We don't have them at the county park. So we're looking at ways that we can enhance the resident experience out here as well as part of our overall plan. And there's, like I said, there's a lot more. That report is very comprehensive, but that's just kind of a overview of what we're looking to do. So I'm going to flip back to the overall possibilities, and with that, I'll be happy to take any questions, and we'll go from there.
Thank you, Adam. Commissioner Marriott?
Thanks. Hey, Adam, thanks. That's very comprehensive. I appreciate it. One quick question for you. What are the hours that we enforce parking?
So we enforce all of our city lots from 8 to 8. The county park's 24 hours currently.
Okay. So I think I have just a couple comments, I'll start by saying that generally I'm in favor of most of these things, and I think we have to try it to know what happens, right? I think that, you know, like we've seen with the freebie, when we charge more money, you know, there's a point at which we'll charge enough money that people will use it less, and our revenue predictions might not be the same, but we won't know till we try that. I have a little bit of concern in District 1 that as we increase the parking rates, we'll push more people into the neighborhoods. And again, that's something we'll find out if it happens, and that's the good news of how we're going about this. It's easier to pivot and change and adapt as we get more information. And so you said we enforce from 8 to 8.
Yes, that's when we charge. So yes,
when we charge, yeah.
And I'll tell you, you know, from an enforcement perspective, it is a relatively challenging position to fill in some cases, especially our part-time one, which is basically nights and weekends.
Yeah.
But we are full staffed right now, which is pretty recent that we became full staff. So certainly, in some cases where I've heard issues with a lack of enforcement, I'm hopeful that that'll pick up now that we're full staffed. And again, we're kind of looking at some of these technology advancements so that we can maximize our enforcement efforts.
My only comment about the exact possibilities here that I have is that, and I'm probably the one who was most in favor of lowering the parking fee by $1 in the morning, you know, to give people a time to go to the beach, and people who are just walking or surfing or things like that to not charge them as much money. I would say that looking at this and thinking about it, I would be more tempted to say that, like, how about on the weekdays we just don't enforce till 9 or 10, and then you know, and make it public. You know, have it on the, you know, that parking on weekdays is from, you know, 10 a.m. to 8 p.m. and because noon is probably a little bit too late, or maybe even just bump our enforcement back an hour on weekdays, just to give those people that are you know, kind of early morning sports recreation people a little more opportunity to go to the beach and do their thing in a time when it's very underused. But go, you know, those 10 a.m. to noon hours, probably you especially on the weekends, but even on the weekdays, you start to get a lot of people stacking up, and, you know. So anyway, that's my only comment.
And to your point, and again, we put 8 to noon, just to show you what that looks like. Certainly, whatever the commission likes, we're happy to look at. I'll tell you, even at 8 o'clock, you're looking at, 190, almost $200,000 in lost revenue if you weren't doing it at 8 o'clock. So,
Between 8 and 9, just on weekdays?
yeah, no, that's overall. So that's including weekends.
Yeah. No, I would just be talking about weekdays.
Yeah, I got you.
Yeah.
Commissioner Maldonado?
Again, thank you, Adam. When was the last increase that we had?
I would have to get that for you. I don't remember when it was approved, so right after the hurricanes in October is when we put it into place. What we found when we started managing the parking, that the commission had approved an increase and it hadn't made it to all of the meters yet. So I would say the last time it went up on the meters was the October, shortly after the hurricane, so about a year and a half ago.
Okay, thank you. So, yeah, I don't agree that we should pass through the credit card fees. I think that, part of our allure is that we should share and essentially eat those. I don't agree that we should reduce the rates. I think that the revenue loss there in itself is considerable. I do agree with all of the recommendations from the Finance and Budget Review Committee. Thank you.
Thank you.
Wrong way.
Commissioner Woznicki?
I just want to say that I agree with that. That I do like the recommendation from the Finance Board as well. Not in favor of the reduction or passing the credit card.
We need $213 million. I'm in favor of getting every penny we can, including credit card fees. I really have no opposition to that. I don't, it's 26 cents per transaction. It's another, significant amount.
I'm sorry, I'm
We need consensus. We need consensus at some point.
I swear
so-
I stepped in here when I took office, and I can tell you it was like right after I took office, and we talked about the fees, and I flat out said, I think $6 an hour, and here where we're at. So just saying. Because my experience that I had said was that 35 years ago when I went to Waikiki, it was $6 an hour. And we are one of the #1 beaches, or we're number 5, I guess, now or so, in the state of Florida. And with that comes a price on that. And there's a lot of usage out on the beach that needs to be taken care of. So, yeah, I'm fine with it. I mean, as far as the credit card fees, I know that downtown St. Pete is, you pay a lot less, but I'm not getting what I'm getting at here. And they do pass through the fees. What do the other cities do? Are they passing through the fees? Are they not? I mean...
I'd have to get back to you. I'm not, as far as our local ones, I'm not sure, to be honest with you.
Yeah. I prefer that than trying to give back, lower the pricing by $1 before noon. And I would think that would probably be, if we were to do that, that would be the 8 to 10 and not really the noon. But I would agree with, all the recommendations. I will back the Finance and Review Board.
So it seems like the majority is in favor of the Finance and Budget Review Board. What we can do is we can draft the resolution based on that, and then we'll have the opportunity for public input at that time. And certainly we have all these figures. It's I don't want to say it's relatively easy to do because Kathleen's going to manage it, but she's a rock star. But it is relatively easy to make those changes if when it comes before you all, if you'd like to make any changes to it.
Should we do, and also with this holiday rate, do an event rate? Should we consider that as well?
Certainly could.
Considering, I think we have an item of discussion tonight as well, and there's been other larger events, and if that's the future of the city, then that's something as well to consider.
And that could be something where, when we start getting these special event permits, maybe that's something that we bring to you at the same time, that we could bring that special event rate. Again, like I mentioned, the technology is getting better. Right now, I'd be hesitant to say that I could get it implemented. If we approve it on a Tuesday, I could get it implemented by a Saturday to to be in place. But I do think eventually the technology is going to get there to be able to do that. So I don't think that's long off that we'd be able to do something like that.
Commissioner Marriott?
Yeah, I was just going to say, I think as far as the special event rate goes, I think that might be a down the road. I mean, I think we have, there may be an upcoming exception, but for the most part, most of our special events are not really citywide. And I'm not sure we have the technology currently to have parking be one rate at Pass a Grill and a different rate at Upham, and, you know, or how workable that is right now, immediately. So, you know, but I also am fine with passing through the credit card fees. I mean, I think that's become a very, that's become a very common thing. I can hardly think of a transaction I've paid with my credit card in that kind of, especially with an app or in that kind of a service business where you don't pay the credit card fee. I don't think that's a,
Yeah, you're getting more and more of that even when you go out to eat.
yeah.
Okay, so how many do we have in favor of the credit card?
I'm just
Passing through,
Yeah.
Oh, well, I wasn't sure on Commissioner Robinson because she's
Oh,
mentioned both. So the only other item I would add to this is not necessarily that we need to decide this today, but I would definitely have a chat with the businesses in Pass a Grill, you know, 8th Avenue primarily, especially the restaurants. From all the ones that I've heard, when I say they dislike, I'm really being gentle in the language I'm using on the $25 fee. And even some of the other boutiques and, you know, other shops, because if somebody's coming for breakfast, you know, if they pay $5, $6, they're there for an hour, hour and a half, that's fine. But then to have and in some cases, for example, the Seahorse, there's nothing else available if it's not in their 5 spots, right? That's across the street, and everything over there is going to be that $25 minimum on the weekends, right? So I would be just curious to find out what the revenue difference is going to be if we switch it to just flat hourly like everything else versus going from 25 to 40. Now, that wouldn't preclude us from doing a special events, you know, if there is a special event happening, to still do something, but I think most of those businesses really would appreciate. So I would say just let's compare the numbers so we have real data to compare it with and be able to make a decision based on that, and also have a conversation with them about, you know, if the data is the same, then I certainly take their point. If the numbers end up being the same, then it's more work for us anyway. Commissioner?
I agree with that. I was just going to ask, do we have that granular of level of data to know how many people are paying the daily fee versus paying hourly on a holiday, you know, or on a holiday rate? Do we only have the daily fee on a holiday rate?
On a holiday, everybody pays the holiday rate. There is no
hourly.
anywhere.
Okay.
But we do have the data to evaluate what if we did X in one location, like Pass a Grill, and Y in another location.
Mm-hmm.
And so we know on those holidays do we know how long anybody stayed? Because they paid the daily rate, so we don't have any idea how long they stayed.
So we have 2 parking providers. One of them tells us when the duration that the car paid for, and the other does not. It just tells us the starting.
Okay.
But we do know how many cars,
Yeah.
right?
Yeah.
How many transactions?
We should be able to you know, a close approximation or extrapolation from that data.
Yeah, let's put our heads together and take a look at that. I definitely think that's a legitimate concern, and it was brought up in the parking study. So let us see if we can get that to you before we bring back the resolution, or at least when we bring back the resolution. The other thing, I'm just thinking out loud, but we could conceivably put a special event rate in the actual fee you know, the fee calendar. We don't necessarily have to put it in place immediately, but then it'll have been approved, and it may be quicker for us to be able to implement it. So that's something we can look at too. I wouldn't be able to give you any data on how much that's going to raise, because we wouldn't know how many special events or how many people, but, you know, maybe something that we could get approved, and then that way, if we want to implement it at some point, we could we could do it quicker. So just a
Yeah.
thought.
And too bad there can't be some sort of voucher, because if there could be a voucher, then anybody frequenting those shops on that time period, on those days, could use that to get it as something to think about.
I'm excited where the technology is going, but we're not,
They're not
we're
gonna
not
be
quite there
there
yet. But I do think the future is going to be bright, especially with the new company. That's kind of, Kathleen mentioned, we have 2 companies right now. They're taking over both of them, and it's going to help us a lot because we're going through 2 completely different companies right now, which is challenging.
Maybe it's something you can ask them if they have any ideas on that,
Certainly.
because that might solve a lot of those problems.
Thank you, Adam.
Thank you.
Next, we have general audience comments.
John Rondolino.
If you please
Good
state your
evening.
name and address for the record.
John Rondolino, and the property's 3191 South Maritana Drive in Don Cesar Place. It's one of the waterfront strips. And I'm speaking on the seawall issue, and I just have some points. I'll try to go quick because time's limited. I don't think there's anything in the code that mandates people upgrade their seawalls. It's just if you come in, you've got to do this. With the exception of, I heard tonight, for new homes, they're looking at mandating new seawalls. And all the talk seemed to be on bay or canal properties. The seawall ordinance also includes Gulf front properties, so you'd be requiring 6 foot, not from the physical ground, 6 foot from whatever the elevation is, along all the property lines on any homes that are built on the Gulf. Something to consider whether you want to do that or not. I think your goal is to have people that have old dilapidated seawalls replaced. And seawalls, tonight was the first I've ever heard that seawalls are designed to retain rainwater. Seawalls are designed to keep the sea off the property. So from a variance standpoint, when you're talking about, in order to get a variance, you have to prove that you're retaining 24-hour or 24-year, whatever, stormwater. That has nothing to do with seawalls. Everybody I know that has a seawall has drain holes in them or rocks behind them so that the water goes in and then drains out the seawall. So there should be nothing in the variance about requiring some study for stormwater related to your seawall. The next part is on elevation. Y'all require 5 foot elevation and 6 feet on the Gulf. And every time I've talked to anybody about it, they said that's for safety concerns. If there's a big storm, you have to have 5 foot elevations. In Don Cesar Place, the road in front of my property is 1.78 feet. And my seawall, which is built in 2020, was surveyed at 2.93 feet. There's never a normal high tide that comes over that seawall. It's only during a hurricane there's going to be an issue. The high tide issue is because the city uses 24-inch drainage pipes through the seawall, and so when the tide comes up, anytime it's above 1.78 inches, the water floods the streets over there. If 5 feet is really that important, then you should allow, if not mandate, that people that are building new homes raise the elevation of their properties to 5 feet. So that if it's a flooding issue you're concerned with, it should be a flooding issue that a homeowner that wants to raise their property to a flood elevation can raise it. The average elevation on my lot that's across the street at 3190 is 2.9 feet, I think. I should be allowed, if the 5 feet elevation is such an issue, to grade that property to a 5 foot elevation. I'd still be mandated to have engineering studies so that it retains all the stormwater and doesn't flood anybody's property. Last thing real quick.
Thank you, sir.
Don Cesar.
Thank you, sir. We're
right.
trying to keep everybody consistent. Thank you.
Kathy Garshow.
I was going to speak on the ordinance, sorry, on the agenda.
Oh, okay.
Sorry about that. Thanks.
Deborah Scheckner.
If you please state your name and address for the record.
Deborah Scheckner. One quick comment about the seawalls. So in my neighborhood, and I'm sure many of the others, way back when, if you didn't have 3 adjacent homeowners that would agree to a seawall, there was no seawalls. I have several areas like that. So I don't know how you're going to address those, if you're going to make the people, put up a seawall or not. So that, I didn't hear it mentioned, so that's why I said that to you now, so you are aware of it. And then I think it's also important, I can't tell you how many people didn't know tomorrow is voting day. All those cards, all that information. And they said, we have a vote on March 10th. Yes, you do. So there must be some strong disengagement there, although every year there are people who don't know that that's the next day is voting day, and hopefully that they all show up, because to me that's very, very important for our community, is to have that participation of voters. And I always hold that dear. Since I'm 18, I've never missed a vote in my life, even small ones. So I wish more people would take that as serious as I do and others. But good luck to everybody tomorrow, and I think we should charge the credit card fees. People are used to it. Thank you.
Thank you.
John Kurzman.
If you please state your name and address for the record.
John Kurzman, be Honda Way. On seawalls, if you could zoom into the actual picture, it would be really helpful. I happened to be just in Blind Pass last weekend, and I took a picture because I admired it. They have seawalls, and then they go to having actual sandy beach, and then one house even has a wall there. So I would just ask that, if it's possible, if we could make sure that we consider people to do certain things like that. The other thing on the seawalls is I'm concerned because if you raise a wall and you don't backfill, you just make a bathtub, and you make a bathtub for the rain. You make a bathtub if the water gets on the wrong side. So it's really important to do the filling. But I find it interesting that the new rating system from FEMA no longer considers your BFE in your price. If your BFE changes, your price doesn't change for national flood insurance. It now looks at the lowest adjacent grade, natural grade. It would be great if we could build moats around us, then we'd pay the least amount. Part of the problem is they developed it thinking about rivers, that if you filled, you then blocked water and caused the water to raise because you're in a ravine and a fixed amount. But that's not the Gulf. So I would recommend you get your lobbyists to be working on fixing that. On the parking, I think you could charge a fee for credit cards if people have a choice to pay cash. But if you don't have a choice to pay cash, and it's just always going to happen, just raise your rate. And if you had some data, which I think Commissioner Marriott was asking for, about what would we lose on weekdays waiting till 9 a.m. What would we lose on weekends waiting till 10 a.m.? What would we lose maybe even 11 a.m.? That might be a good approach to then, because that would help. And then on sunset, if someone comes and only shows up during the sunset hours, I'd recommend charging the higher amount. But if they were here all day and they just had these extra hours at the end, I wouldn't change the rate. It might also encourage people to come even more before sunset, do some shopping, or go to a bar or something. On the cellular, I was in this industry, and also, after 9/11, I walked around New York with a radiation meter, and I had an RF meter, and I checked properties with the Geiger counter. I'm concerned about this stuff. But, 5G has gone down a lot in power, but now it's in the microwave band, so I understand the concern. My suggestion is to address the 30-foot, make it 30 feet from the setback line, because the next house might be closer to the street, but also say the higher of 30 feet or the height of the pole. So if you're a 40-foot pole, then you need to be 40 feet away. And that justifies it. And lastly, watch out for that 500-foot rule, because let's say AT&T again wanted to go to Gulf Boulevard. you might now force them to now be in front of a residence because of the 500-foot rule. So just be careful. Thank you.
Thank you, sir.
Kelly Lee McFrederick.
If you'll please state your name and address for the record.
Hi, Kelly Lee McFrederick, 3612 East Maritana Drive. And my only concern with the seawalls is because our docks were built in 1926, I have two concerns. So one of them is my middle section. We're looking at, when we talk about yay without a permit or without paying permit fees, but there's two things I want to state on. One was, we're looking at accessibilities to our existing docks. And I really do want to make sure, how are those going to be permitted? How are those going to be approved? We had issues with my historic dock before because the county said, you have what others don't have, it needs to come down. So I do have a concern of how many permits are needed and will the permits pass if we do things correctly as good citizens. That being said, number two is we have not addressed, or have I not heard about the commercial. We're 2 doors down from Hotel Zamora. Are their docks going to have, or excuse me, are their seawalls have to be improved as well? Because we can take mine, I don't want to go 5 feet, I'll be honest with you, I just want to go 3. I'm really good with that, work with that. I have riprap, I maintain my seawall. It's in pretty good shape for how it is. I've done foam inside of there, we keep it maintained. I've had to backfill it from the ski slope and some other items that are next to it. But as Hotel Zamora and some of the commercial areas, are they going to also have, are they going to be mandated to raise their seawalls? Because why would I do mine if they don't? Because their water is just going to go right up into my yard and my neighbor's yard. And my neighbor's seawall is in much worse shape on the west side of my house. People on the other side have both improved both their seawalls. So we're willing, you know, it's just a lot to undertake. And we also want to have a voice on what it looks like in terms of how they're engineered. I told you before, I wanted fans where they would just spread out. I do not want all my landscaping and pavers and everything ripped out like it looks 2 doors down from me. So I really do want to have a voice in that, but my concern is the commercial properties, that those are also mandated. And of course, we've talked about the boat ramp and other areas, that we all do this as a joint community, I think is very huge. But I think we all need to have a say, and I agree with what John was saying of maybe we don't need to go to 5 feet and look like a citadel. Thank you.
Thank you.
I have no more general audience comments.
Thank you. Is there a motion to approve the consent agenda?
I move that we approve the consent agenda.
City Clerk, if you'll please do a roll call.
Commissioner Robinson?
Yes.
Commissioner Rosnicki?
Yes.
Commissioner Maldonado?
Yes.
Vice Mayor Marriott?
Yes.
Mayor Petrillo?
Yes.
Motion carries.
Next, we have ordinances. 5A, final reading of ordinance 2026-02.
An ordinance of the City of St. Pete Beach, Florida, amending Appendix A of the City Code of Ordinances relating to parking fees, removing parking fees from Appendix A, providing the parking fees shall be established and amended by resolution of the City Commission, providing for codification, conflicts, severability, scrivener's errors, construction, publication, and an effective date.
Good evening again, Adam Poyer, Assistant City Manager. Again, this is just the final reading of the ordinance. We've made no changes since the first reading, but I'm happy to answer any questions that you may have.
Thank you. Questions, comments? Are there any audience comments?
There are no audience comments on this issue.
Thank you. Is there a motion?
Make the motion to adopt the final reading of ordinance 2026-02.
Second.
Commissioner Rosnicki?
Yes.
Commissioner Maldonado?
Yes.
Vice Mayor Marriott?
Yes.
Commissioner Robinson?
Yes.
And Mayor Petrillo?
Yes.
The motion carries.
Thank you. Next, we have ordinance 5B, final reading of ordinance 2026-03.
An ordinance of the City of St. Pete Beach, Florida, providing for amendments to the Code of Ordinances, Chapter 132, Communication Facilities in the City Right-of-Way, Section 132-16, Design Standards, providing for codification, conflicts, severability, correction of scrivener's errors, construction, publication, and an effective date.
Thank you.
I can introduce the basic changes.
Please.
I did want to say at 6 o'clock this evening, we received a letter from Verizon, from the Schutz Law and Bowen Law Firm, which I'll distribute, and there's a copy for the clerk. So between the first reading and today, we met with the citizens' attorneys and also discussed with the Verizon and AT&T attorneys. The changes that we have to both the staff alternative and the residents are presented in your board packet. As the attorney, Scott McCullough, pointed out, it basically boils down to a couple of things. One is that staff is still recommending 30 feet from an existing dwelling unit, where the residents are seeking 40 feet. The residents proposed a distance of 10 feet from the driveway apron and 30 feet from a fire hydrant. Staff agrees, but is citing, instead of saying exact separation distances, we're citing to the codes that have those distances in them, and that's the Land Development Code Section 2.1 for traffic visibility, and the minimum distances required by the NFPA and local code amendments for a fire hydrant for public safety purposes. And these 10 feet and 30 feet is something the staff has already been applying to utility poles and, or excuse me, to wireless facility poles. The additional section that we both agree to is to place wireless facilities and new utility poles with new wireless support structures near common interior side lot lines, subject to the driveway and fire hydrant limitations, rather than directly in front of the principal facade of a residence. And the residents have now agreed with staff alternative to do the negotiation period rather than the variance. The second point was the 500 feet that the residents were proposing as a minimum separation distance. Instead, the staff has not wanted to put a actual number on it. So instead of doing a minimum distance separation, we asked for a maximum distance to the extent possible and technically feasible from other small wireless facilities in the public right-of-way without limiting communications service. So that will be considered and determined on a case-by-case basis. We agreed also with the residents to add to the criteria in 2E, failure to comply with applicable codes, including specific rules or restrictions applicable to any historic district applicable to the site's location. So that was agreeable language to both. So with that, I think we have answers to any questions. Brandon Barry is here to talk a little bit about the setbacks, the 40 feet versus the 30 feet, and what's feasible.
Good evening, Brandon Barry, planner. So there are two proposals before you. The staff alternative is proposing a 30-foot setback where viable. That's from the residential dwelling itself, not from the property line. The citizen proposal has also been updated to a 40-foot setback. I believe in the prior proposal that was from the property line, not 40 feet, it was 30 feet at the time. The 40 feet is from the nearest existing residential dwelling unit or structure that has been submitted for permitting and declared complete. Between the two, obviously 30 foot is much easier to accommodate. Typically the right-of-way distance in the city outside of Paso Grill, it's much shallower in Paso Grill, is between 12 and 18 feet. Typically the front setback requirement for a new structure is 20 feet from the property line, so that leaves a curb to potential building distance of between 32 and 38 feet. Most areas in the city, there is some variation. There's typically a significantly greater distance between the curb and the property line at intersections. In some older neighborhoods, there are areas of the Don Cesar neighborhood, for example, that have building setbacks of 30 to 40 feet just based on the historical patterns of that area. But typically the older neighborhoods have greater setbacks to the structures. Outside of Paso Grill, newer structures we found are typically built very close to the front property line in most cases. So a 30-foot setback, which in the staff proposal is a recommendation, it's when it's technically feasible to accommodate. That would be more easy to accommodate in most neighborhoods. 40 feet would be a challenge in certain areas. It wouldn't preclude wireless support structures. or wireless facilities, but it would be a more difficult to accommodate in most neighborhoods. Happy to take any questions.
Thank you. Questions, comments for city attorney or city staff? Commissioner Maldonado?
Yeah, thank you, Brandon. So I'm just looking at it. I want to make sure I understand this. So you did make the adjustment and the recommendation to 40 feet from the property or dwelling, correct?
Staff is still at 30.
It's still at 30. Okay, so I'm going to do a little show and tell. If I can get our assistant city manager to help me here. Please bear with me for just a second. If we can operate this thing. I've tried to find the lowest technology possible, so perfect. If you'd go out to 30 feet.
I saw this in a movie. I did too. I was thinking the same thing.
30 feet. Now hold it from the podium here.
It's kind of funny movie too.
30 feet, Adam.
I'm here.
Okay, tighten it
You
up.
might want to tighten it, yeah.
All right, Dean, if I could get you to stand there. I'll go back to 40, if you could. You got some election equipment, so that's what we're talking. We're talking about 30 to 40 feet when the pole's 40 feet, correct? Grant? The average pole length is 40?
For the ones that support transmission lines, are typically 40 to 45 feet in height.
Okay. Perfect. Okay, thanks. So I just wanted to show you something that what we have here is a critical safety issue. If something falls at 40 feet when we're recommending 30, then it's pointless. So we're looking at litigation with 37 people versus maybe 2 entities. Correct? I'm just doing simple math here. Trying to get this down is distilled as much as possible. So what I am going to essentially recommend is that we change that to 40. And this is, I do realize that there's unique circumstances with distance in Paso Grill and other locations, but I've said this from the very beginning, it has to have teeth. And for it to have 30 feet distance serves no purpose. We're essentially setting ourselves up for failure 37 times. So. And that's all I've got to say on that. It's going to go back and forth. I do see that.
Do you have any thoughts on the 500-foot?
Struggling with that. I'd like to hear what some of the other commissioners have to say, and then I'll circle back to that piece.
Okay. Commissioner Marriott?
Thank you. Brandon, I just have one question for you. On the, Commissioner Maldonado was just talking about the poles, the average height of the poles being 40 feet tall that have transmission lines on them. And are the wireless antennas that we're talking about, are those generally mounted at the tops of the poles?
Right, they typically extend above. We frequently see 5 to 7 feet above that height, and then they're allowed 10 under the statute, but it typically is 5 to 7.
Okay, so effectively they're even taller than that.
Correct.
Okay.
Some of the tallest poles we have are 51 to 53 feet with the antennas on top.
Okay, thank you.
Commissioner Reznicki?
For the 500 feet, and this would be, I guess, a question to legal. What can we focus on the aesthetics of the city? We're not talking about separation. Or I think what we're also talking about is how the city is going to look. If we're not limiting how many are in a certain area, aesthetically, we could have a forest of poles, and I'll give an example that's right by City Hall. I mean, everybody's seen the forest of poles that exists right between City Hall and the library. I don't know what street, and maybe Commissioner Robinson knows what number or name, if it's a name, because I don't remember. The one right here behind us, it's by the library. There's like literally, I don't know, every 10
on
feet.
The hardening poles that are the...
Just to give a visual, correct.
Hardening poles?
Right, I'm not saying those are communication, but I'm just saying of because we don't limit anything, that's what it looks like right there. So why can't we focus on the aesthetics of what our city could look like if we're not limiting poles?
City Clerk, do we have any audience comments?
Roger, oh,
If you'll please state your name and address for the record.
My name's Roger Hood. I live at 109 Second Avenue, a property I've had for almost 36 years. For the 27 years prior to the storm, I lived around the corner on Passagirl Way till that house washed away. So I moved, lucky enough to have a house to move into about 4 doors away. But I do have a pole, the one that Brandon was talking about, the one that's 50 feet high. So there's some concerns. I'm here also to support the requested changes. But my concerns are, for point of reference, my house is 36 feet from that 50-foot pole. The head of my bed's a little bit closer than the front door. So there's the aesthetic issue is one else. Again, I was a realtor. I'm concerned if I went to sell my house that the health issues are real or perceived. They're going to affect the eventual cost. Or if there's another comparable house down the street without a tower smack in front of it, I'm not going to ever sell the house. One other issue is I've had Verizon for 35 years, and I'm not an engineer. My background is in telecom, but I'm not the engineering side. But that tower went in. I don't know for a fact that it was fired up, but since it went in, my service, I'm going to probably end up having to change. My cell service is unacceptable. My calls drop. I can't hear the person on the other end, and it doesn't happen in the car when I'm away. It happens when I'm home, and it happens on every call. Multiple times I can't hear the party I'm talking to. It blacks out. So the aesthetic values, the issues of safety, little off subject. A few years back, we changed the street signs in Paso Grill. I called Mike Clark to say, boy, that's a little change, but they made a huge difference as far as adding to the quaintness of the town. And I think the cell towers do just the opposite. I think instead of adding to the aesthetics, I think they take away from such a quaint, special town as Paso Grill. Yeah, that's it. Thank you.
Thank you, sir.
Ron Vigneault,
If you'll please state your name and address for the record.
Yeah, my name is Ronald Vigneault from Paso Grill. So by this time, you all know how I feel about what's going on. And I called my mom today before this meeting, and I asked her some advice. She's 82 years old. How am I going to go on about this? And she said, just talk about love. And she's right. She's a wise woman. It's all about how we love ourselves enough to do the right thing. Okay. Obviously, my wife and I we've been talking about this for a year, and you guys have been talking about this for a year. So it really comes down to love. If we're going to love ourselves enough tonight to do something about it, and it's going to be okay, because every time people do things coming from a place of love, they are supported. And it's not all about money. I mean, you didn't pick this job for money. You can make a lot more money somewhere else. You pick this job because you love your community and you want to do something about it. So that's the time to do it. That's tonight. Thank you.
Thanks, Ron.
Lauren Moniz,
If you'll please state your name and address for the record.
Lauren Moniz from Paso Grill. So I had a speech plan, but I think I'll go off that and talk about the separation, because I think that's really the contentious thing. But so the 500 feet separation, it's not just about which is approximately 2 blocks. So if you can imagine, 2 blocks is just not a lot, right? But I'm pretty sure these telecom companies want these every 50 feet. And can you imagine having these every 50 feet? So it is, like Betty said, it's an aesthetic issue. And like my lawyer said, we can use the term and the provision of concealment to defend this 500 feet separation, because that is allowed in the Florida statute 337.401. Because, you know, even Roger's pole, have you guys been to the beach and looked at his pole? It's terrible, you know, not to mention what he has to look out from his bedroom window. So it's not just about how far these towers go, but like, what is our city gonna look like? You know, like on Gulf Boulevard, those cement things are just everywhere. And some of those probably will turn into wireless towers. I mean, that's what they're looking like right now. So I just can't imagine. And like I said in my speech is like, but also I wanted to go back to what Karen said earlier today is we won't know what happens unless we try it. She said that about the parking, right? We won't know what happens unless we try this. And like my attorney also said, there's not going to be a lawsuit on the ordinance. They're going to submit applications, and if that goes against our ordinance, then we bring it to the negotiation table, and then, but I don't see us not being able to negotiate this stuff, you know? Like, I don't see, like, there being fights about this, because there's always alternative locations, always. They'll say no, but there always is. So, you know, I don't think we should base this policy from a fear of a lawsuit because of what my lawyer said, and also just doing the right thing, protecting the residents. This is what the majority of people want. You guys know where I'm at, so that's it. Thank you.
Thank you.
Dean Lurker.
Thank you. Dean Lurker, Passive Grill. I rise also in support of the residents' request for 40-foot considerations stand back for the purposes of safety for our dwellings. I appreciate the visual demonstration of what we're talking about footage-wise. I also do believe in the 500-foot mandate, or at least 500-foot separation. I can understand why telecom companies want to have maybe denser population because of the double M small 5G wave does not do well in dense foliage areas, nor does it do well where there's a lot of concrete construction. We don't have that in Passive Grill. We don't have that in St. Pete Beach. Everything's pretty open. So they'll have good transmission capabilities. So I would recommend certainly the 500-foot at least separation, and also support the idea of the aesthetic impact it's going to have on our community, our bucolic community that we all love and cherish. So thank you.
Nancy Lurker.
Nancy Lurker, 1405 Passive Grill Way. I'm going to repeat what everyone else did. Betty, thank you for bringing this up because that was going to be my opening comment, which is the 40-foot, my husband already talked about that, and then the 500-foot. I'm sure you've all seen them. You go look at these things. They are ugly. And to have, I can't imagine that we could have, or that we have no limits at all on how many can get put. So we're spending, I don't know how much money, I'm guessing over $1 million or more, taking down telephone lines or whatever, the electrical lines on Gulf Boulevard, partly I know for hurricane reinforcement, but also aesthetically. And then we're going to go put these these cell phone towers everywhere. Go take a look at the one that's on the old, the large estate on Passive Grill Way. That thing is ugly. Pardon? Thank you. I can't imagine they're going to be happy with that. I don't want one of those sitting in front of my house. Not to mention it's going to bring the value down. So I would just encourage, we do what we can, go to the 500-foot distance in particular, and then the 40-foot for safety reasons. Thank you.
John Kurzman. Kelly Lee McFrederick.
Hi there, Kelly Lee McFrederick, 3612 East Maritana Way, East Maritana Drive, excuse me. Just real quick, thought it was interesting, 60 Minutes just recently did a segment on the Havana Syndrome. It's the same thing that these 5G towers do to us. And they're now starting to get awareness of this, and we're going to be continuing. We've actually, from a federal level, been asked to write to 60 Minutes to exploit this, continuing more with what the radiation can do to us. So the demonstration was fantastic, because we know mine was 24 feet from property line, so 10 more feet was 30. So basically where your 40 was, my driveway's here. It's there. And that mine was actually, I believe, about 60 feet, plus the 5 feet on top of it. So it is quite an impact. And I know we don't live, in fact, as we know, Maritana, for those that don't know, sorry about that, is on the Intercoastal Waterway. This is not what we want on the Intercoastal Waterway. I don't need it to affect us, the wildlife, everything in the water. It's going to affect Bella Vista. It's going to hit them. That's going to radiate right over to them if we continue along the Intercoastal Waterway. And the point I brought up last time was the fact that we're not, as the gentleman said, we're not a place of hills, valleys, and trees. We have enough, and 500 feet does protect the neighborhoods. We're very adamant about that. We're also talking with the FCC directly. One of my other neighbors is really calling in. We're learning about this because we know AT&T wants to directly come out and say, if I have you every 50, 60 feet, which has been brought out, you have to have my equipment because none of your equipment is going to work, and that's a fact. So we definitely do not want a monopoly, and we're looking at Verizon, AT&T, some of the other ones actually just fighting with each other, saying, hey, you cannot have this monopoly. We should be able to have a choice. And we know that we're going to go to Starlink and some other items, and what's going to happen to these poles down the road. But aesthetically, the other gentleman was right, Roger, who said, who's going to buy my house if they put mine back up as compared to one down the road? My property value would be completely impacted. And people are getting smarter and smarter and smarter, and they know better. And so I do think this is something that is realistic. I definitely am in force of it. I know you all had a lot of emails sent to you. I've got quite a little war weapon behind me of wonderful girlfriends that are aware of this and love their homes, and they really want to see this go forward. So I appreciate you hearing us, and I hope for this to pass tonight, that we make this happen. The 40 feet, 500 feet is very, very important, and 60 Minutes has this. It'll just take a little phone call, and they'll hear some more about this, and we'll get some more information. Making us important is what I'm talking about with 60 Minutes, that they can make us important, that we know there's going to be a lot more information coming out, and we're looking at doing the right thing now. Thank you all.
Jack Rice.
Jack Rice, 3612 East Maritana. Can I say anything about the flood too, or just about the? Okay, all right. So the flood water, rainwater, if I put a seawall up, it's going to impact her house because it's going to go from my water back to her water and flood her house. It's the dumbest thing I ever heard. Anyway, I said the same thing before. The one on Pat's Grill next to Augie Bush's house, you're wrong. It's below the light. It's not above the light. I can almost reach it with my hand, so you're wrong. Staff has no idea what they're talking about. This is bad. I'm so tired of being here. I'd rather be home watching something, sports, something else. This is ridiculous. I've been here 6 times, 7 times in the last 2 months. This is ridiculous. You guys need to stand up for us. It's just ridiculous. Do the right thing no matter what. We don't need any more towers. Just say no more towers. Just have it at that. Pure and simple. So tired of this.
Kathy Garchow.
Kathy Garshaw, 3607 Casablanca. I just wanted to speak on behalf of the community and support of the direction. Thank you, Commissioner Maldonado, for bringing that measuring tape. I think that was brilliant.
Excuse me, sir.
I wanted to show something on here. Oh, thank you. Just one. I think you all have this, but it already says we have 100% coverage. So I think that's one thing we all just have to look at and say. So if our experts show we have 100% coverage. I don't know. I think that's one thing we just have to look at. The other thing everyone's been talking about, so I know I've shared some pictures like this before. They're not good. Our utility friends are not good neighbors. I take a short walk within less than a mile of my house. And this just is an image of a lot of sad-looking, unkept utility lines and poles all along. Duct tape. I mean, it makes our city look terrible. So even now they want to throw up new things. So I just wanted to share a couple of these things because I don't know ultimately what the legal impact is like the experts do, but just logically and as a resident, it just doesn't make any sense. So I hope we can support this.
Deborah Scheckner.
I'll drive in St. Pete Beach. I think I remember a show called Mad Max, and it was like a terrible future, and it was all dark. That's what those poles looked like to me when I saw them. And I took a ride around the city to see how many there were, and it was surprising to me. I think we have to also find a way. How do you mitigate the loss of your real estate? 10, 20, 30%, who knows how much that will be. And that's a significant hardship for anybody who has that pole in or near their house. When we went looking for homes, if there was those large transmission lines, we immediately said no. We didn't even go in the house. That was not. So I think other people are like that too, especially people who may be health conscious or whatever. What I really thought was weird is as I was looking up, Duke needs to do a much better job on their wires. Things are hanging. We pay a lot of money. We pay more per rate than North Carolina pays. Because we're Florida and the utilities think they can charge us anything they want. And pretty much through the years, they've said, okay. So we already pay more and we get less. So I would like Duke to come out here and do a better job just doing those wires. And I wonder, so we had 4G, 5G, is there a 6G down the road and then we have to do something totally different? What will the new technology be? But I really do worry more about the homeowners. And I truly hope that they can sort of mitigate this, or the city can help them. I don't have the answer to that, but I don't think any of us want it in front of our houses. Thank you.
I have no further comments.
All right, thank you. Commissioners? Commissioner Marriott?
Yeah, I've got a couple of questions for our city attorney. Do you agree with the residents' lawyer's assessment that if we pass the residents' proposed language, that ordinance wouldn't be challenged as an ordinance, but it would just be per tower if we don't allow them on a per tower basis?
Well, I think there's two parts. If we could think of the 30 or 40-foot setback, we could probably go to 40 there with the city's staff language, changing 30 to 40, keeping it encouraged. The second one is the minimum separation, the 500 feet. The statute says the city may not limit the placement by minimum separation distance of small wireless facilities, utility poles on small wireless facilities are or will be co-located, or other at-grade communication facilities. I think it would be very hard to defend that 500 foot as not being a minimum separation distance. I think it's being proposed by the residents as a minimum separation distance. So I think it would be hard to defend that.
Okay.
And then I think there would be a challenge, probably facially, because it's so clearly a minimum separation district distance, and the statute says that. And there's another Florida statute under chapter, I think it's 120, that awards attorneys fees if cities adopt ordinances that are in violation of state preemptions. So I think they would see that as low-hanging fruit and probably do a facial challenge on that minimum separation.
And once that challenge was begun, the city would be on the hook for their legal fees.
If we lose, yes.
Okay. So I think, I don't think this is I don't think we should be looking at this as having to choose between being for the residents or for the telecom companies, right? I think what we're all trying to do is adopt an ordinance that can be defended, because an ordinance that can stay in place is infinitely more valuable than one that does not survive a legal challenge. And I think we need to be very clear. We need to go, whatever we do, we need to go into it very clear-eyed about the potential risks and costs. And so, I don't feel comfortable putting the city in the position of carrying the torch and leading the charge for us being the test case in Florida to see what is defensible. I don't feel like we're a big enough city with a big enough budget to take that risk. I am 100% for using our lobbyists to lobby at the federal and the state level to get some of these things changed. And I am absolutely for changing the distance to 40 feet, particularly if we keep the staff language of encouraged. The encouraged are required as long as there's a negotiation period. I'm not sure what the ultimate difference is, because we can still, even if our language is encouraged, we can still deny a permit application, on a per pole basis. And we could choose to have a legal fight on a per pole basis, which, if somebody's trying to put a tower in a particularly egregious spot, we could choose that legal fight that may be a more winnable or a more possible fight. So my feeling is that, we have that as an option. I'm not comfortable with the 500-foot separation. I think, I don't think there's any reasonable way to read that state statute and think that we can put in a 500-foot separation without being in direct contradiction to state statute.
Commissioner Robinson?
I'll start with the 40 feet. I am for that, but I'm also for the lesser of 100% or 40 feet. In case they were to go higher or lower, we'd still have the 40-foot protection on that. Being if, they did a 30-foot, they could do a 30-foot, not requiring them to necessarily be 40 feet. I think that's a little bit of a give and take. But we are seeing towers that are larger, so we also have that coverage as well. The 500-foot, I'm very happy to see some things that happened since the last meeting that staff worked hard on. The fire hydrants, the driveways, the reference to codes. There were a couple things I brought up, but whether we had anything in regards to gas lines, any of that. But that reference does help as well. There was a item brought up, very expensive one, that if we underground, if the whole city is undergrounded, that just gets rid of this problem. But that's a very expensive solution to that. The 500-foot, is there anything that we can do in here in regards to, as was mentioned, aesthetic, in reference to aesthetic or concealment? And I asked that back to the city attorney. Because I think we're getting there, not as fast as everybody would like, and not as much as everybody would like, but I am definitely for the health, safety, and welfare of the residents and the community. I know that this was in 2017, the Florida League of Cities filed a challenge to this preemption itself, and they lost. But I think this is worth going forward with these changes to be able to protect the residents. And more so on a safety. I mean, health is definitely a potential concern, because I just remember what's been, when it was fine to use your cell phone, and then all of a sudden it's, oh, maybe you shouldn't be holding that next to your head every day, every hour. So we just don't know what's in the future. And I do agree with Kathy's, we don't have really good, what do I want to say, partners in our utility companies, because I do the same thing. I walk through this city and I see the horrible disarray of every utility company that's put anything in the ground and all the boxes in the ground and everything out there. And so I am concerned aesthetically on what this city is going to look like, and I'm concerned on the health and safety of the community as well. So I ask.
I guess you had a couple of questions. One is about aesthetic and one in concealment.
Right.
So right now we can control the color of the paint, similar to aesthetic and concealment, or paint or wrapped. I think one of the companies wrote that they don't like to use wraps, they want to use paint, so we made that an option in the ordinance that we already adopted. There is a bill pending in the legislature. The last day of the session is Friday. If that bill passes, we can't do landscaping requirements. If it doesn't pass, maybe we can. We won't know until after Friday. I mean, one suggestion that we could do is that we could do the staff language and then substitute 40 for 30. And then for the other one, which is the 500, it shows up as number 3 here. We already have number 1 and number 2 on the citizens' proposal, but we could make number 3 a new subsection 4 and leave in the 500, so that that way if we get sued and that gets stricken or we have to repeal it, we can repeal that, but we still have the staff language in there as a number 2. So we would adopt staff's alternative for number 2. And if you were to adopt the residents' 500-foot language, which is 3, that would be in there as a new subsection. And I believe we can make sure we have a good section at the end of our code. It's called severability. It says the provisions of this ordinance are declared to be severable, and if any section, sentence, clause, or phrase of this ordinance shall for any reason be held to be invalid or unconstitutional, such decision shall not affect the validity of the remaining sections, sentences, clauses, and phrases of this ordinance, as they shall remain in effect, it being the legislative intent that this ordinance shall stand notwithstanding the invalidity of any part. So if the citizens' part gets stricken, the other ones would remain. You still would run the risk of paying attorney's fees, however many hours were incurred, up to the point that you might repeal or have a court strike it.
Commissioner Maldonado.
Thank you, Attorney Brooks. So, yeah, that just made my decision even easier. So at this point, yeah, I would say at least 500 feet wherever possible and technically feasible without limiting communication services for the separation as a new subsection.
I know at the last meeting I asked if we could do something besides distance. For example, density, units per
We looked at that, the statute says we can't limit the number of facilities. So if you're looking at the number per acre, I think that would be a limitation on the number.
So is it same boat?
You can't say you can only have 100 in the whole city. Yeah.
But we're not saying.
Or you couldn't say you couldn't have 100 in the particular neighborhood.
No, but I was asking specifically if you could say X number per square mile. So we're not
We
limiting.
can look at it some more, but it seemed that was limiting the number. Or a minimum separation distance. That's another possibility we can look at. And bring back to you.
Well, I was hoping to have that answer today since it was asked twice already.
I guess in my opinion, that would be a limitation on the number and probably would be preempted. Just like the minimum separation distance is probably preempted. We get out of subsection 5 that has some kind of density limitation, but I don't know how you would even phrase that.
Well, I'm not saying we need it in addition to, I'm simply saying as an alternative to the 500.
We could ask Brandon to come up. Is there any way you think that we could phrase a density, something similar to density for communication facilities?
I can't think of anything offhand, and like the city attorney said, there's, I'll try to find the language, but it says that the city cannot limit the location of a utility pole to support wireless or small wireless facilities. So I think that's the challenge. We could think it over some more, but I don't have anything right now.
They haven't said that yet, but I said think about this section. Citizen. Section.
Is there a motion?
Make the motion to adopt with modification of 40-foot setback from dwellings unless varianced and 500 separation requirements where possible and technically feasible without limiting communication services for the final reading of ordinance 2026-03.
Did you want to include the additional language about the negotiation period? Everything that's in the citizens' proposal here?
Yeah. Yeah.
Because again, this goes to more than just ground equipment now. Now this is all support structures and poles.
Can we do that as a subsection?
It would be a new subsection 4 to take their 3 and that entire
That's
3
6.
paragraphs and make that a new subsection.
Absolutely, yep.
And we'll add in the 500 feet whenever possible and technically feasible without impacting coverage.
Is that the final version of the motion?
Yes, it is.
I'll second. City Clerk?
Commissioner Maldonado,
Yes.
Vice Mayor Marriott,
No.
Commissioner Robinson,
Yes.
Commissioner Ruznicki,
Yes.
and Mayor Petrilla.
Yes.
The motion carries.
Thank you. Next, we have action items. First one is 6A, Resolution 2026-06, to grant an easement to Duke Energy.
A resolution of the City Commission of the City of St. Pete Beach granting a 10-foot by 10-foot limited purpose utility easement to Duke Energy Florida and providing for an effective date.
There's no staff report. I'm just here to answer any questions.
This is just for one utility box that goes in the ground at the corner closest to the street.
Are there any audience comments?
Oh, I did
There are
want
no
to say,
audience comments on this.
I did want to say that Camden was, expressing to me that he would like to do these utility easements as narrow as possible from now on. So that's why we're seeing 10 by 10. We're going to try to make the smallest areas, try to deal with some of the cleanups that were pointed out in the prior presentation with the pictures of utility stuff everywhere. We want to make sure it's all compact.
Sure. Is there a motion?
I make a motion to adopt Resolution 2026-06.
Second.
City Clerk?
Vice Mayor Marriott?
Yes.
Commissioner Robinson?
Yes.
Commissioner Rosnicki?
Yes.
Commissioner Maldonado?
Yes.
And Mayor Petrola?
Yes.
The motion carries.
Next, we have action item 6B, Resolution 2026-05, to waive permit fees for seawall repairs and right-of-way.
It's a resolution of the City Commission of the City of St. Pete Beach to temporarily waive building permit and plans examination fees for private seawall permits adjoining city rights-of-way beginning March 10th, 2026 through and including March 10th, 2028, and providing for an effective date.
So we have just a single slide to show it was requested from the commission to look at the possible impact that would be incurred should the permitting fees be waived for these seawalls adjacent to the right-of-way. So there's an estimated 4,575 lineal feet of seawall that are adjacent to the public right-of-way. What we did is we pulled all the permits post-storm to current to look for seawalls to look at what the average cost was. What that equated to was $1,108 per lineal foot. Multiplied by how many lineal feet is roughly $5 million in the value of that work, which equates to $83,000 roughly in permitting fees. So that would be what would be potentially waived. And I'd be happy to answer any questions if you have any.
Commissioner Robinson?
How many homes does that include? Or properties? Do you know?
Not 100% sure.
I think we're in about the 60 range.
It's 5,000, 8,000, 80,000 divide 40 properties.
Roughly 40 homes?
41 properties.
Okay. And I'm just trying to get a feel for, I just feel like this is just so pointed to one area, and I know it is, but I also feel that it needs to be opened up to other areas as well, for everybody. I mean, it shouldn't just be exclusive to if somebody wants to redo their, and that's what we're trying to do here, right? We're trying to get resiliency all around the whole bit. So isn't this an opportunity to allow anybody who wants to go ahead and redo their seawall the opportunity to get a chance within this 2-year period to have the fees waived for that? I just feel that it should be, across the board for the community and not necessarily just in the right-of-way.
That's certainly a commission decision. I don't have the analysis done for you citywide. We're in the process of doing a citywide seawall study, which will be complete in 2027. So if that's a decision you want to make based on estimates, I would need a little more time to get you a back of the napkin estimate. I'd need at least 18 months to get you an official, more detailed analysis of the state of all the seawalls in the city.
I think Commissioner Robinson is just, you're saying waiving permit fees for seawalls, period.
Yeah.
For the next 2 years.
Yep.
You said we did 80 some odd seawalls this year?
83 up to this point from October 1 of '24.
Okay, so 83 times 5,068 is roughly 400,000 and some change a year.
It's $2,000 a permit. I'm just trying to think.
Well, no, the average permit is $5,000.
Right.
And so if it's 83 properties, then that's a little over $400,000 a year. And so we would have to come up with that. So the reason we're doing a proposal is for seawalls adjacent to right-of-ways is because it abuts the city property, and then it's we're sharing the cost a little bit with the residents in those areas. And I agree with you that we need to be as resilient as possible. I just don't know that we have the ability right now, in light of all the other expenses that we have, to, take $400,000 off the table. It was with the permit fees that we waived before, we were at least being reimbursed by FEMA.
Right.
So that $4.5 million that we waived before, with this one, there's no way to recuperate it.
Would there be worth talking about a way to open it up to other areas afterwards? I mean, it needs to be equitable across the island for those people that are looking to redo their seawalls.
Well, it might be worth if we just get actual numbers and data, and then we can see what the numbers are. But for the purpose of tonight, I'm fine with this one as is. If we wanted to expand it, I would certainly like to have actual numbers that we can make those decisions on. Commissioner Marriott?
Thank you. I agree. I think that I think this is a great start, and I think this is important because, like you say, these are seawalls that abut city property as well, and so we're helping out with these resident seawalls just on the permit fees so that we can also protect city assets, and so I think that's important. And I think that it absolutely is something we should look at down the road to expand this program potentially, or some kind of program to more homeowners who are looking at seawalls, whether it be waiving fees for people who do living shorelines or living seawalls or any number of things that we can do. And I think that as time goes on and we get more data, I think we'll have a mid-year budget adjustment here and we'll know how much money the building department is taking in. I'm sure the building department is taking in record revenues with the number of permits that have been pulled in the last, even if you don't count the ones that we weren't charging for. But I think that can be a separate issue from this one that we're looking at tonight.
Commissioner Rosnicki?
I would just say I agree both with all three of you, because you've all kind of hit the same thing. Just to remember that the difference is because of this right-of-way. And in essence, it's not just about the private property seawall. It is the property of the public as well. So by encouraging homeowners to improve that private seawall, it in turn helps protect our roads, our sidewalks, the utilities that run into the ground along all of these right-of-ways that abut them. And also the drainage system. I mean, if you know, some of our CIPs, our capital improvement projects are up and coming, have to do with drainage in some of these areas. And we're about to invest a lot of money as a city. And if these seawalls are not secured, I mean, it's kind of like we're just putting money down the hole. So again, just because this is in reference to the specific right-of-way, like you see this image here, that's really what we're talking about. I do want in the future to do the same thing that you're mentioning, is to make the coastline all around of our city more resilient, and hopefully we can get some data in the future, to help encourage citywide to do the same thing. Thank you.
Are there any audience comments?
Kathy Garchow?
Kathy Garshaw, Don Cesar Place. My first comment is just on behalf of the Don Cesar Property Owners Corporation Board. We just had a meeting tonight, so on behalf of them, we absolutely support the easing of these permit fees temporarily to try to accelerate the, the development that we need on these seawalls that are in disrepair, where we know that about a little less than 20% of our homeowners impact 100% of our neighborhood in terms of our ability to get around the Maritana streets. So we need that. It's vital to the resiliency of our neighborhood and the future investments that I think the city hopefully will be making to help us address a lot of the flooding issues that we already know we have in that area. So just wanted to put that as a part of the board message to you all. Thank you. On a personal note, I just wanted to if it's okay, just say something about the parking, because I do want to mention that, as somebody said, yes, we are getting people parking in our emboldened to park in any of these empty lots in our neighborhoods. And I guess the sheriff, which that's fine, they can't do anything about, that's what they said, but maybe the city could help us with a towing company, because I had a neighbor who had 2 people park right in their driveway and left for the beach because their house is under construction and they couldn't get anybody to come out. So maybe there would be a towing company that might be more readily available to our city. So that's just on a separate note. Last comment, again, personally, I want to thank you, Mayor Petrilla and Commissioner Rosnicki. I know we have a big election tomorrow. You guys have put everything out there. Thank you so much for your service, however this works out, and all of you. I know you pour a lot of blood, sweat, and tears into this role, and it's can be a thankless role, so thank you.
Thank you. Is there a motion? Oh, sorry.
Sorry, I have one more comment.
Don Cesar Place. We've been working on the resiliency committee for forever. One of the issues, out of the roughly 75 10-foot strip lots that surround Don Cesar Place, and I think this is directed 100% at Don Cesar Place, because that 10-foot strip is abutted by Maritana on the whole side. There's probably, I think in the study that we talked about, 40 or 50 of those that have old seawalls that are a problem. And there's probably 25 of them that are original seawalls from 1925 that just keep no water out. So when there's normal high tides, it's not, you wouldn't be looking at waiving permitting fees for all 75, because there's a whole bunch of properties that have seawalls that are perfectly fine. But we're really struggling with, how do you get some of these people that have lived there for 30, 40 years to have to spend $40,000 or $50,000 to replace this old seawall? If the seawall's not replaced, we're continuing to have normal high tide, full moon flooding that floods the streets. The city then puts these giant pumps out here and has to use staff to go out, refuel, repair the pumps to get the salt water out. If there's some way that we could provide an incentive for those people to say, hey, maybe now's the time for me to go put a seawall in that's allowed to be 3 feet because the road's at 2 feet, to reduce their cost and waive the permit fees, it would be great, so that we can then move on and figure out how to stop some of the other flooding issues if we can resolve the high tide issue that comes in. So I agree it'd be great down the road if the city decided to waive some fees for people that had dilapidated seawalls in other areas. But in this concern, it's actually costing the city money, because you have to keep the pumps out there and the maintenance of the pumps and clean everything out because of all the seawater that comes in over these old seawalls, some of which aren't even existing any longer. Thank you.
There are no further audience comments.
Just one last comment, and there's not a lot, and I appreciate that he just mentioned what he did, because there's not a lot that need to be done. But I also wanted to recognize those who have already stepped up to do their seawalls in the time that, this resolution was drawn. So I want to be able to request that it goes to the storm, not just January 1st. And there's not many. I think there might have been 1, maybe 2 permits that had already been submitted to do their seawall. One that did go to the 5 Nav, by the way, and then others that are kind of pending, maybe after a look at our seawall ordinance that we mentioned at our presentation. So I'm just asking, because it's not many, like we've just said, and I'll draw the motion, but it is to go retro to Helene.
Is that your motion?
So I do motion to adopt Resolution 2026-05 with the amendment of retroing back to Hurricane Helene.
Second?
City Clerk?
Commissioner Robinson?
Yes.
Commissioner Ruznicki?
Yes.
Commissioner Maldonado?
Yes.
Vice Mayor Marriott?
Yes.
And Mayor Petrilla?
Yes.
The motion carries.
Thank you. Next, we have items for discussion. Commissioner Maldonado.
Country Thunder. We've heard a lot of it recently. It was featured on a podcast, and it's starting to get a lot of exposure. I've been having lots and lots of questions. I just wanted to bring it to the attention of the commission, hopefully have some input to the city manager. I know that it'll be, if approved, it'll be a large gathering, so therefore it's going to require resources committed from the city, standing up the EOC, partnering with PCSO on getting additional folks out here just in terms of crowd control and preparedness. I also wanted to say that I support it, that I think that it's a great thing for St. Pete Beach to have large venues come and experience what it is that we have to offer, with the caveat that I don't want it on the beach. I think that we should propose to them that they use the parking spaces. We have lots of wildlife. This is the height of the nesting season for the turtles as well as the black skimmers. And I've heard rumors of folks moving nests and talking about contingency plans to work with wildlife conservative or conservatory agencies and things like that. And I'm not comfortable with that piece. But outside of that, I think it's a great opportunity, an economic boost for our restaurants, hoteliers, and local businesses and establishments. But I do want a cost estimate on what it's going to cost the city, how we're going to fund that, if we're going to directly bill the organizers, and to just be very transparent about it. I'd like to hear how the commission feels about this event, and if they have any input to the county in terms of issuing a permit. Thank you.
Thank you.
My thoughts would be it's just at the wrong time of year. I mean, it's at nesting season for turtles and for skimmers. It wouldn't be the first time we've had a large event out here, but it is something on the beach of this magnitude, and with the crowd that's not going to be paying for tickets, is going to be all over the beach. And that is a huge concern, strictly from a lot of areas, but my big concern would be for the simple fact of the turtle nesting season and as well the skimmers. Because once we lose them, we will continue, and we keep doing anything like this during their season, we will not get them back. They will not come back. And we have a comp plan that has nothing but our love for sea turtles and our love for our environment, and here we are stepping all over it. I just find it kind of rude and insulting to actually have it be proposed during that time of year, especially when we're sitting talking about beach ordinances and doing the lighting and doing everything else. I worked the Hangout Festival in Gulf Shores, Alabama, and I know what it takes to put on something like this. And it's going to be a week before putting everything up, and it's going to be a week after. And if they don't have their act together, which I've heard that they are, that they do, but they haven't done one of these on the beach before. But I just find it hypocritical of us to sit there and talk about how much we love, love, love our sea turtles and love our skimmers and love our, our beaches and all this sort of stuff, but we'll just, sell them out. And it's sad. That's how I personally feel about it. So, wrong time of year.
Do we have a status of where they are on permit or overall, just the event?
They're still in the process with the Department of Environmental Protection and Fish and Wildlife through the state. They have to get a state permit to do this type of event on the beach.
Is the city a part of that decision that's made with the permitting, do they ask us about our ordinances and what we have as far as protections of the sea turtles? I mean, they're not interacting with us at all?
They are not. We've sent our concerns to them, but they are not inviting us. Let's just say we don't have a seat at the table.
So they don't care.
Well, is there another way that we can, and I'll give an example, because it happened in the Don Cesar when we had the horses, the polo event that was held behind the Don Cesar Hotel, which happened twice. First time, there was a lot of hassle, environmentally on the beach because of what happened. They were reprimanded. It happened twice again. And then they didn't go for the third time because we pretty much drew up a stink about and literally a stink, about what happened over there. So again, those are examples of, we know this could happen. It already has happened, and we weren't, and I think back then we were involved, because I think I was president at that time, and I thought we were part of a meeting when that permit went in for the polo event that was held on the beach. So I quite don't understand how we're not involved with the permitting process for this big event that could be held on a beach, or why it changed, because I thought we were supposed to be involved. And I don't know, and I'm looking back there because you're all like, but you might not have been involved, but I know it's not the same staff, but I remember there was involvement because I was part of the complaining about what happened, and it's basically, it was, the horses' feces was all over the beach. No one picked it up. The drainage, there was direct discharge into our storm drains. Okay, it was a huge problem, and it happened 2 times in a row. And then they didn't give them that third permit after those 2 times in a row happened. So it's kind of like someone needs to remind whoever's up there, don't you remember this happened already before? And why we were very concerned about something potentially even worse happening with an event that is actually way bigger than that event was. I don't know if we can look into it, but not if we know. We should look into it. We should be calling and talking about this.
Well, we should demand a formal input in terms of our concerns, and they should be responded to. Obviously, Commissioner Robinson brings up the first and most important thing is that our wildlife, either we're with them or we're against them. And if there's plans being made to disrupt or to somehow hamper what's currently going on there, then that's a red line for me. And that's why I said I highly support it. I think it's a great thing for the city, but I don't think that it should be on the beach. There's plenty of room on the property to have it off of the beach. And that could be a contingency plan that they could get ahead of and understand that that's our position. We're willing to partner with them however we can, but I find it difficult to believe that they haven't come to us for any kind of official input. So, but maybe it's because we're not asking.
Can I ask another question too? Definitely on the environmental, but also on the safety for all the residents and those who live close to that area, because it's going to draw, like you said, you might buy a ticket, but you might not buy a ticket, right? So
There'll be a lot not buying a ticket.
There'll be a lot not buying a ticket, and where are they all going to park? Because they're going to be circulating districts 1, 2, I would assume, right? Because it will be the closest to walk or elsewhere, because you can park all the way in Paso Grill and maybe ride freebie over there. I'm just saying it could happen, or you could walk the whole beach. Like, what is the involvement of the city as far as?
I think it might be appropriate to give you probably a presentation, because you're asking a lot of details that some they've provided, some they haven't given us all the detail yet. But it's a no parking event, meaning
Shuttle in, Uber in, whatever.
you have to shuttle in from Tropicana or Uber in. So there's a lot of
moving parts.
moving parts that I
What
think,
she kind of mentioned, because I know they'll say they're going to park off, but how are they going to protect the city also for those who will be circulating for spaces in the neighborhoods or on people's driveway, like Kathy mentioned?
It would be nice to think that they're going to go and frequent the bars and the restaurants, but they're going to be eating the food of the the food and the booze of the festival itself. And that's kind of the reality of what festivals do. There might be some residual from, I'm sure there would be from the hotel occupancy in that regards, but from the actual festival goers from a day-to-day, and depending upon what the schedule is, it's going to be difficult. So, and I don't think any of us know what the schedule is, because that hasn't been publicized. And it's ironic that somebody's out there doing, selling tickets and doing all this when they haven't even secured.
Permit.
So it's a bit presumptuous. And I'm assuming this is an administrative permit. They can say yes or no.
It's an administrative special event permit.
All right, thank you. Next, we'll move on to staff reports. City Clerk.
Just as a reminder, the municipal election is tomorrow, March 10th. The polling location for Districts 1 and 2 is here in City Hall, and the polling locations for Districts 3 and 4 is the Warren Webster Building. Polls will be open from 7 a.m. to 7 p.m.
Thank you. City Manager.
I just want to take a minute to personally acknowledge Brandon Berry, who is our senior planner, and if you were watching this evening, he was here. He covers a vast amount of city policy review, interpretation, recommendations. His job is very difficult, and we would be extremely crippled without him. It does trouble me when he's attacked by community members in a public meeting, so I just want to personally say, as his city manager, since I represent the employees, he's doing a great job, so thank you.
Thank you. City Attorney.
I'd second that about Brandon Berry. He's excellent, a great resource for us. We did receive one pro se piece of litigation. It's a certiorari petition. Was filed pro se by a resident without the benefit of a lawyer. It's Barbara Holler versus City of St. Pete Beach and CP St. Pete LLC, and this deals with the 702 Pass-A-Grill Way Board of Adjustment variance that was approved. It was properly styled in the circuit court, but it was filed in the District Court of Appeals, so it was mailed to the wrong courthouse. That court received it, and they gave the petitioner, Barbara Holler, I think 15 days to explain why it shouldn't be sent back to the circuit court, and of course it will be sent back there. And did want to also report that we do have insurance defense coverage for that case. And that case is similar to the certiorari cases that we have with the Serrata and the trade winds. They're basically an appeal that's based on the record and the court reporter's transcript of the proceeding and an appendix. So it's an appellate type proceeding. There'll be no trial.
Thank you. District 4.
Okay, thank you. Just a reminder that our community meeting is next Monday, the 16th, 6 p.m. at the Warren Webster. And I echo your comments about Brandon Berry. He's probably one of the, if not the tip of the spear when it comes to knowledge, and just an expert in everything that he does. So he is definitely due the recognition and everything that he gets for that. So thank you.
District 3.
I just want to say the same thing about Brendan. I don't think it was called for in a meeting to attack a staff. I think we should uphold as a commission when something like that happens in the future that we recognize it as well. It was uncalled for. I think we all know what a great employee you have, and you know, if you're listening, Brendan, you know that was definitely not called for. So that's all I wanted to say. Thank you.
District 2.
Just want to remind everybody to get out and vote. Tomorrow's voting day. And then I did have a question, Renee. You said Districts 3 and 4, even for mayor, they have to vote over 4, correct? Okay, just want to be clear on that. Over at Warren Webster. And I second and third and fourth the comments on Brandon. And as well, I guess, I will venture and put that out to anybody, including everybody sitting up here, because I don't think anybody said anything on that for the mayor when he was attacked as well. So, I will say we should be doing more points of order up here. And that goes for everybody, so.
District 1?
So I just want to remind everybody that there's the first spring concert in the park is this Friday, I believe. And then the Corey Avenue St. Patrick's Day Street Party is the next day on Saturday. And I just want to give the folks at the Corey Avenue Business Association props for putting on some really great events lately. And Corey Avenue's really been hopping, and there's a really nice mixture of stores there. And I've gotten lots of comments from visitors to the town that, you know, how lucky we are to have that and how unique it is in Pinellas County up and down the beach communities. So we're really, really thankful that we have those guys over there on Corey Avenue making things happen.
Thank you. Thank you, everyone. We are adjourned.